I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast, I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past. And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains at last, and to believe in what you got, it was built to last, yeah.
Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play
Lento appearing on behalf of the state.
Assistant Prosecutor Jamie Schroen for the state.
Good morning, Ms. Lento. Good morning, Ms. Schroen. Good morning, Your Honor. Mario Bellucci, along with Andrea Ferrante on behalf of Christopher Gregor, who's seated next.
Good morning.
Good morning, everyone. Hi, Mr. Gregor. Mr. Gregor appears again in a suit and tie, appropriately dressed for court. Jury is ready. Counsel asked a conference on a couple of issues, so that was the reason for the delay. I suppose we have the jurors come over now and go in the jury room. We can discuss any further issues while they're in the jury room.
Yes, Judge, thank you.
All right. Court staff is on the way.
Judge, when the jury goes in the back, before we bring them back out, can I just test sound?
Can you do what?
Can I test the sound when the jury
Yes,
goes?
absolutely,
Thank you.
yes. That was my plan. We can discuss anything we need to while the jury goes in.
Okay, thank you.
You can test. Thank you, Corporal Ben.
Do you have everything you need?
Yeah, we just have the videos to play and that's it. Okay, this one, right? It's 48.
No, she's those.
Oh, okay.
These are mine.
Those are the ones you have. So
Yep,
you have
that's
one.
this. This is this one. Yep. I'm going to drag this to my desktop when the jury's not in the room.
It's 9:36 a.m. The jury's in the jury room. Anything from counsel outside the presence of the jury?
Your Honor, I think they approach sidebar.
Sir.
Thank you. Judge?
Counsel asked to speak in chambers this morning about various scheduling difficulties with respect to witnesses. We've decided that we're going to go with the state's witnesses today, see how far we get, and then make a determination about tomorrow and later in the week as well as next week. The witnesses in this case, many of them are either medical professionals and or have significant distances to travel to get here. So, and some of them have other prior commitments where they're unavailable for certain dates. So we're going to address that as we go along this week. In addition, court anticipates testimony is going to come out with respect to the defendant being in the state of Tennessee and perhaps elsewhere after April 2nd, 2021. We previously had various 104 hearings outside the presence of the jury on that issue, and counsel had asked me to defer a final decision until such time as the trial testimony occurred. Accordingly, I need some time outside the presence of the jury, either at the end of the day today, to put some more findings on the record. Mr. Gallucci, we already marked as Court Exhibit C4 proposed charge on an allegation of flight. Is it correct that you have no objection to me placing those additional findings on the record after the fact?
I do not, Judge.
Thank you. And then last week I read a charge to the jury on the photographs from the autopsy. Madam Clerk, I don't believe we ever marked that as a court exhibit. Did you mark that? C9 next in order, thank you. It is now, yes. And then, I did a proposed charge on deleted text messages, which Mr. McCullough is going to print and give to you right now. We anticipate Sergeant Coles is going to testify consistent with his prior testimony at a 104 hearing about the deletion of text messages from the defendant's phone. I was going to draft that similar to the flight charge, Mr. Deletion, where the defendant has the ability to offer an explanation. Is that explanation that he was being threatened, or is there some other explanation?
That's the explanation, yes.
All right, so we'll give you that charge as drafted. Take a look at it, and at some point let me know if you find it acceptable and when you want me to give it.
If we're going to hear from the detective, I guess, from the CSI unit that went down to Tennessee and took his car and phone, I would probably want it after that.
All right.
All right?
Very good. So we'll have a break or whatever to look through that proposed charge, and you can comment on there any revisions you'd like made to it.
Thank you, Judge.
All right. Anything else from counsel?
No, Judge, thank you.
Ms. Strong, do you have an opportunity to test the video?
I'm going to do that right now. Judge.
Okay, go ahead.
Thank you. The TV is not set to be connected to my computer, but it is.
It might be, until we put it back. Can you check that, Madam Clerk? There you go.
Thank you.
Jan 1553, may I please have your name and your contact number? And what's your address at home?
It's 900 Farmgate Boulevard in North.
Is that good enough?
Yeah, I think
Okay.
you could,
And the
yes.
one that says cut. And it was correct and everything.
That's when you got consent, right? You want to listen to it?
I can listen to the cut version. Marilyn, do you want me to play the cut real quick so we can see how it sounds? Judge, we're just making sure on this that everybody agrees about the cut version.
Have your name and your contact number.
Sure, it's Chris Gregor, my number.
Have you called from an agency or a facility today?
No. MICCIOLO.
And your address at home?
It's 900 Farmgate Boulevard in North. Unit 903 in Farmgate.
Your home.
Just my dog, my son, and me.
Alright, and who is the mother to the child?
That is the person I'm calling about.
Chris?
Correct.
Okay, and where does she live at?
I am unsure.
Do you have a phone number for her or any credit contact?
I don't have it readily available, but you guys have been involved with us, so I'm sure that it's in the documentation.
Do you want to listen to all of them? Yeah. Sure.
Alright, and what were the concerns today for the child?
So, as my son had described, that it was from football. Now, fast forward to yesterday, actually, it was this past weekend, my son needed to go get an evaluation done within 7 business days, or 7 days, excuse me. His son's mother, and I had no idea what was going on. She would not leave my son's side, and I was not able to be there for my son. And then furthermore, my son came back this morning, and he was stating to me that his mom said that he had to tell the doctor that I had hit him and things of that nature and coaching him. I tried to call up the caseworker, but of course he's not answering. She said that the caseworker told her to disregard the visitation and to go to the hospital.
No, I'm just going, I'm sorry, I'm going over the specific redactions with Mr.
Coming up
Galucci.
right now.
Restrict any sort of contact with
Let's
them,
skip
any
it.
sort of documentation or court order involvement, kind of stating that. So that does not appear accurate. But I mean, and I can obviously note what you're telling me, and I know that the worker didn't answer, and the worker is probably.
Did I skip it?
The office is closed today. So this information will get, passed on to a worker. That way they can see this information as part of the case. But no, there's nobody available at this point in order for me to speak to.
No, and I figured as much, but I wanted to document that my son came home today after he was supposed to come home at 5, so I was not able to be there for my son.
Okay.
And he said it was at the direction of DCP&G. And furthermore, the big issue for me is, she put in an abuse allegation and said it to the lawyer twice.
Okay.
One held up.
Good. All right, so the court made a prior ruling about the redaction of certain statements from that recording. Mr. Galucci, you're satisfied those have been redacted?
I am, Judge.
You bring the jury out? Any further?
No. Thank you.
Thank you. Jury out at 9:48.
Good, right?
Jury out. All rise. Okay.
We're changing it up today?
Please be seated.
That you have your phone.
Your Honor, he has his phone because it helps control his hearing aids.
So, sir, I recall what you're saying that you want to be able to use that to amplify the sound?
Yes.
All right, and you understand, obviously, you can't do anything else with it, correct? Thank you. Well, good morning, ladies and gentlemen. Thank you again for your patience and your presence here today. Any concerns or issues you need to bring up at all? All right, seeing none, we're going to proceed with the state's next witness. Who would that be?
Your Honor, the state will call Lindsay Carnival, please.
Thank you.
Lindsay Carnival.
Hi, ma'am. Good morning. Come on up. I just ask you to remain standing, face the court reporter. She will swear you in. If you'd raise your right hand.
Do you solemnly swear the testimony you're about to give in this proceeding, or affirm this testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth? Thank you. Have a seat, please.
Lindsay Carnival. Carnevale.
Thank you. Ms. Lento.
Thank you, Judge. What is your occupation?
I am a registered nurse.
And where do you work?
Southern Ocean Medical Center.
And what department do you work at?
In the emergency room.
And before you worked at SOCH, where did you work?
I recently went to Jersey Shore and worked in the NICU for a little while. It wasn't suitable for me. I like being in the emergency room, so I went back to SOCH.
Okay, and how long have you been a registered nurse for?
Almost 4 years.
Now, before you were a registered nurse, what was your occupation?
I was a paramedic.
Where did you work as a paramedic?
At Monarch,
How long did you work as a paramedic for?
about 15 years.
Can you tell the jurors about your education?
I went to paramedic school for 2 years. I have advanced cardiac life support, pediatric advanced life support, CPR certified.
And you have a bachelor's degree?
I do. I have associates and a bachelor's in nursing.
And what about an associate's degree?
I do.
And what certifications do you currently hold? And can you just keep your voice up a little bit so we can hear you back
Oh,
here?
sorry. I hold the ACLS, Advanced Cardiac Life Support, Pediatric Advanced Life Support, my CPR, which is Basic Life Support.
Now, calling your attention to April 2nd, 2021, at approximately 3:53 p.m., did you treat a patient at SOCH named Corey Micciolo?
I did.
Had Corey been admitted into the emergency room at that time?
He was.
Do you remember Corey?
Of course I do, yes.
Who brought Corey into the emergency room that day?
His father.
When Corey was admitted into the emergency room, what room was he taken to?
In room 6.
What nurse brought Corey to room 6?
Bill Doyle.
Were you Corey's assigned nurse on April 2nd, 2021?
I was.
Where did you first observe Corey in the emergency room?
In room 6.
Was Corey's father inside room 6 when you first saw Corey?
Yes.
Did you speak to Corey's father?
Yes.
Did you learn his name?
Yes.
What was Corey's father's name?
Chris Gregor.
What were your immediate observations of Corey's condition in room 6 at the emergency room?
Corey was very lethargic, pale. He was very sick.
Were vital signs taken?
His temperature was 96.9, I believe.
And what about blood? Was that drawn?
Yes.
When Corey was initially in room 6 of the emergency room, what was the defendant's demeanor?
He showed lack of emotion, kind of emotionless.
While you were in room 6, who else was present in the room?
Dr. Pichotti and other nursing staff.
And what about Nurse Doyle?
Yes.
And did he stay in the whole room or did he leave?
He left.
And when you observed Corey in room 6, did you see any bruising on his body?
Yes, we did.
Can you tell the jurors what bruising you observed?
I observed a bruise on his chest, a bruise under his chin, and one on his temple, his left side temple.
While you were in room 6, did medical staff speak to the defendant about a case history relating to Corey?
Yes, we did.
And what did the defendant say about the bruising?
He said the bruising was from Corey playing football and riding his bicycle.
What did the defendant say about Corey's mother?
That she was a drug addict.
What did the defendant say about contacting Corey's mother at that time?
He said that he did not want her contacted.
And what did the defendant say about Corey being at Jersey Shore Medical Center?
That his mom had him there the night before.
What did the defendant say about Corey's symptoms before he was brought into the emergency room?
That he had been vomiting and he was complaining of light and body pain.
Now, that information, did you provide that to someone?
I did.
And who did you provide that information to?
My nurse manager, Jenna Shaw.
And was she working that day?
She was.
Did the defendant leave room 6 of the emergency room?
He did.
And what was Corey's condition?
Corey was very sick. He mumbled a couple words to me. He seized.
Can you tell the jurors what happened regarding Corey's treatment at the emergency room and his condition?
Corey seized, and then his heart stopped. He had stopped breathing. So we initiated CPR. Dr. Pichotti intubated him, where he put a tube in his trachea and into his lungs, and ventilation was provided along with CPR.
And what type of CPR was administered?
Pediatric CPR.
And why was pediatric CPR administered?
Because he was a 6-year-old little boy.
And what is pediatric CPR?
It's one hand on the chest.
Was Corey taken for a CT scan?
He was. At one point, we had regained pulses, and we attempted to bring him down a CAT scan, and when we had gotten a CAT scan, he lost pulses again, and we were unable to do it and had to bring him back.
So after that, what room was Corey brought back to?
Room 6.
Did the defendant then return to the area of room 6?
He did.
And were you present inside of room 6 at the time?
I was.
And what medical staff was present in room 6 at this point?
Dr. Pachati, there was some techs and other team members.
Did Dr. Pachati exit the room?
He did.
And what was happening with Corey's condition at this time?
Corey was not breathing. His heart was not beating. He was basically dead at that point.
Did the defendant then re-enter the room at Soch?
No.
At approximately 4:51, did the defendant re-enter the room at Soch?
He did at that point, yes.
And were you present at that point inside of room 6 with Corey?
Yes, I was.
And what was Corey's condition at that time?
His heart was not beating and he was not breathing.
Did the defendant exit room 6?
He did.
And did the defendant then ever come back to room 6 again?
No, he did not.
And who stayed with Corey?
We did. We were the only ones with him.
What time was Corey pronounced?
5:03 p.m.
And were you present in the room?
I was.
While Corey was at the hospital, what, if any, observations did you make regarding any type of bleed or GI bleed?
There was no bleeding present.
If I may approach, I'm now going to show the witness what's been marked S48D, S48E, and S48F. Do you recognize those?
I do.
And can you tell the jurors what those are?
They are CDs of surveillance from the hospital the day Corey was admitted to the emergency room.
So that is surveillance from April 2nd of 2021.
Yes.
And that would be the day that you were the nurse in regard to Corey's care.
Yes.
And you are familiar with the location that is depicted.
Yes.
And you are also familiar with the persons who are depicted on these surveillance videos.
Yes.
Your Honor, permission to play, publish, admit into evidence S48D, S48E, and S48F.
Mr. Galucci, any objection?
None, Judge.
S48, D, E, and F in evidence. And permission to publish granted.
Thank you.
D, E, and F. Do you want me to play D now? D.
Can you tell the jurors who is located on that video?
One of our nurses, Jamie.
And does that accurately depict the defendant leaving room 6 for the first time on April 2nd of 2021?
Yes.
And there was a timestamp on that video?
Yes, there was.
And is the timestamp accurate that was on that video?
No.
You can now go to the next video, please. And can you tell the jurors who is located on that video?
Chris Gregor and one of the techs, Richard.
And what area of the hospital does the video show?
The hallway going to the family waiting room.
And there was also a timestamp on that video.
Yes, there was.
Is that the correct time?
No.
If we may now go to the next video, please. Now, can you tell the jurors who is located on that video?
Chris Gregor, Jenna Shaw, Jamie Jocelyn, one of our techs.
And Jenna Shaw, who would that be? Would that be the blonde?
Nurse manager, yeah, the blonde.
And does that video accurately depict the defendant entering room 6 where you were located with Corey?
Yes.
And does that video accurately depict the defendant entering room 6 where you were located with Corey?
Yes.
And can you tell the jurors what was going on with Corey's condition during the time of that video while inside room 6?
We were providing CPR and breathing for him.
And did you see a machine present in that video?
Yeah, Jamie went to grab a Doppler.
And what would be the purpose of the Doppler?
To see if we can find pulses that we can't feel.
And this would have been at approximately 4:51?
I believe so.
And after this time period, did the defendant then ever come back into room 6?
No.
And about how long was Corey treated at SOCH before he was pronounced?
About an hour and 20 minutes.
Thank you, Judge.
No further questions?
No, Judge, thank you.
Mr. Delusion.
I'm sorry.
Remember, the jurors on the end have to hear you, so.
How are you?
I've been better.
So, when Corey was brought in, you were the nurse in charge of his care?
Yes, he was my patient.
So would it be fair to say that at about 4:02, are you familiar with the record right away? Have you ever read the chart?
I looked over the chart, yes.
Okay, so you're aware of the fact that at 4:02 is when he was admitted in critical condition? Yes?
Pretty critical when he came in, yes.
Okay. And at that time, would you take his oxygen level?
Yes.
Okay, do you recall what his oxygen was at that
I
point?
do not recall.
Do we have the medical records?
I have my copy, but I need them for her.
Can I borrow them and give it to her and then give it back to you?
Well, I would like to have a copy for myself.
Can we make a copy of this?
You can look for another copy.
Judge, can I have a second to look for another copy?
Thank you. Thank you.
Yeah?
Sir.
Can you just take a look at that and tell me what that is?
Just tell us what the ticket number is on there, then, please.
This
On the bottom right corner, red.
547 or S47?
S47.
S47.
Is that the hospital record of Corey Micciolo on 4221 at Southern Ocean Medical Center?
Yes.
Okay. And you was a nurse, so you know what that is, right?
Yes.
Okay, and I'm sure you have notations in that record, am I right?
Yes.
Okay. Now that you're not the person, from what I understand, there's also a scribe present?
There's a scribe
Okay.
for the physician.
Right, so the scribe, while the physician's doing whatever he's doing, the scribe is taking down the information so the physician can do what he's doing, right?
Yes, I believe so. I don't do their job, but yes.
But you're a nurse, right?
Mm-hmm.
Okay, so how long you been a nurse now?
4 years
Okay,
almost.
and you've been in the emergency department,
Mhm.
I'm assuming, before, right?
Yeah.
So do you know what a scribe does or doesn't do?
I know they jot down notes from the doctor.
Okay, so that's what they do. They don't take down your notes though, do they?
No.
Okay, you take down your own notes?
Yes.
Okay, is there an indication as to what Corey's oxygen level was when he arrived at that hospital?
I would have to find the vitals in here.
Okay.
Yes, the initial one says 85%.
What's normal? What's normal?
92 to 100.
So he's 7 percentage points lower than what's normal, right?
Correct?
Okay, so that's consistent with the child being shortness of breath, right?
Not necessarily. Could have not been on his finger correctly or not recording correctly,
Well,
which
did you-
happens often.
Okay, well, you're the nurse, right? Did you check to see if that was going on?
We were more worried about him and keeping him alive, and
So
he was
you-
very lethargic.
Well, lethargic and loopy, would that be a condition of a low oxygen level?
Yeah, hypoxic.
Okay, so if he was hypoxic, that would be a concern of yours, am I right?
Of course.
Okay, if he's loopy and tired and has shortness of breath, and you see there's a low oxygen level, is that an indication that you put the thing on wrong? Or the thing is telling you, the whatever you call it, is telling you that the oxygen is low?
Or he wasn't short of breath. He wasn't struggling to breathe when he
Okay, but he was loopy.
He was lethargic.
Okay, lethargic. And that's a sign of low oxygen, am I right?
It could be.
Okay, so you're getting a low oxygen level, aren't you?
Mm-hmm.
Okay. So now he goes into cardiac arrest, basically, right?
Yes, sir.
Okay. And who performs CPR?
One of our techs.
Okay. And the tech, you said, does a one-handed CPR because he's a child, right?
Yes, sir.
And generally, when you do CPR in an adult, you can almost break ribs, am I correct?
CPR is a life-saving measure. Yes,
Right,
we do what we can to save a life.
Okay, I got you. But on a child, it's different, right?
You just use one hand.
Right. A child's ribs, you're not going to break because they're probably malleable at 6 years old. Would you agree with me?
I guess. Depends.
Well, I don't want you to guess. You're a nurse. I'm a lawyer. So here's a 6-year-old's ribs, malleable or not, and is that the reason
Objection,
why
Judge.
you perform CPR differently on a
It's
child?
because they're smaller and their stature is smaller.
Okay.
Objection's overruled, that's fine.
Okay. So it's different, right?
Yeah, it's different. Body
So-
structure is different.
Now, you testified that Mr. Gregor left the room at some point. And I see him being escorted by somebody down the hallway into another room. Who is that person?
One of our techs,
Do you know who?
Richard.
Okay. And why was he escorted?
I'm not sure. I wasn't escorting him.
Okay. Well, were you in the room?
Yeah, I was taking care of his son. I wasn't
Well, did you-
escorting him out of the room.
Okay. Well, is it normal to have a father sit in the room while you're performing life-saving techniques on his son?
Yes.
Okay. So you're saying that he was escorted out of the room because he wanted to get escorted out of the room?
I can't answer that. I don't know. I was paying attention to Corey.
Okay. So if you're paying attention to Corey, how would you know he was under-emotional?
Because I saw him the second time he came in.
Okay. So you're looking at him, not paying attention to Corey, or you're not looking at him and paying attention to Corey?
Both.
You're doing both.
Mhm.
Okay. So you're saying that he was escorted out of the room. You don't know if he was escorted out of the room because he wanted to leave the room or because he was escorted out of the room because you were performing life-saving techniques.
I don't know why he was escorted.
Well, was he brought to a waiting room?
I'm assuming yes, he was.
Is there a waiting room in Southern Ocean Medical Center?
There's multiple.
Okay. Is there a waiting room outside the pediatric unit or wherever we were where room 6 was?
He went to the family waiting room.
Okay. So what's the family room for?
People to sit there and
Wait?
yeah.
Okay. And was he escorted out of there to sit and wait?
I guess I didn't escort him.
Is it the first time you've ever seen a person escorted out of a room in an emergency room?
Objection, Judge. Speculation.
It's overruled.
No.
Okay. So people leave that room when things are being done to patients. Am I right?
Yes.
Okay. Thank you. So now we have a tragedy. The child dies, and somebody goes to get him from the other room. Am I right?
Yes.
And we see him being brought into that room, right?
Yes.
Were you the blonde that was running around trying to hide him? Because there were a number of people in there.
No.
Okay. Where were you at that time?
With Corey.
Okay. So you were actually in treatment room 6?
Yes.
Okay. So while you were in treatment room 6, did you have an opportunity to see Christopher come in?
When he walked in briefly, yes.
Okay. Briefly. By the way, are you a member of Justice for Corey?
Yeah.
Okay. So now you see him brought in,
Mm-hmm.
and then you don't pay any more attention to him.
No.
Okay, so you don't see them bring a chair over for him to sit in?
No, that was outside the room. I was
Okay.
inside the room.
Okay, so you don't see them bring, how big's the room?
Not very big.
Okay, so if this is the bed that Corey's in, where are you?
Right next to the bed.
Okay, so you're here. Where's the doorway?
That way.
How far?
A couple feet.
By their desk or closer to their desk?
Closer to their desk.
Okay. Is that right?
I guess, yeah.
Well, I wasn't there.
Yes.
Okay. So you're saying you're standing here, and you don't see them bring a chair, you don't see him crying, you don't see any of that?
I didn't see them bring a chair, no.
Okay. Did you see it just now?
I did.
Okay. Did you see them have to bring screens to give him privacy?
We do that with every...
Okay. Did you do it in this one? I don't care about everybody else. Was it done?
It's common
Okay.
practice, yes.
Okay, but it was done, right?
Yes.
Okay. Was he having a breakdown?
Uh,
You don't know. Well, did you just watch the video?
I did. I saw the video.
Okay. When you saw the video, did you see him cry?
I saw him cry.
Did you see him show emotion?
Yeah,
Did you see him upset?
I guess.
Okay. Did you see him have to sit in a chair?
Mm-hmm.
Did you see people have to come to his aid? Did
Yes.
you see them put up privacy screens?
Yes.
You saw all that, right?
You always do that,
Okay.
yes.
Yeah, you always do. But you did in this case, right?
Mhm.
Okay. So he was not emotionless. Right? We just saw the video.
He had lack of emotion.
Okay. Very good. As the nurse, by the way, you said you had 2 bruises. Do you know when you got those bruises?
I do not know.
Okay. Do you know when you got those bruises?
I do not know.
Okay. So, but you're aware of the record, right? Did he have any bony injuries to him?
I'm not sure.
Okay. Look at the record.
I don't read results, but I can look through these.
Judge,
Well, if it's outside your purview, I don't want you to...
Well, the question would be, would it refresh your recollection?
Yeah.
If it doesn't refresh your recollection, then having her read the record is nothing more than hearsay.
Right. Would it refresh your recollection to look through the record to see if he had any...
Yeah, but I don't know what happened after. Like, so I can look, but
No, that's
Well, only if you had the recollection previously and the records would refresh your recollection.
no,
You
I
didn't
don't
know
have.
previously.
I don't know.
All right. Just aim it.
thank you, Judge.
Thank you.
Thank you.
Any read the record?
Where was the defendant located when he was emotionless?
In the room, in the room.
Now, when the defendant left the room, was Corey deceased at that time?
No, we were still providing life-saving care. There was no pronounced. Yeah.
Thank you, Judge. No further questions.
Anything further?
Mayor. When Christopher was brought back into the room from the waiting room, were you still doing life-saving techniques on Corey?
Yes.
Okay. So when he walked in, he was a witness to what was going on at the time.
Yes.
Okay. And that's when he reacted the way he reacted.
Yes.
Now, did there come a point where you stopped those life-saving techniques, and then he was told that Corey had passed.
No.
Okay. Thank you.
No further questions, Judge. Thank you.
Thank you, Your Honor. Leave this?
Yes, certainly. Officer Ben will get back to Ms. Lamb.
Thank you.
Does the state have another witness, or do you need another moment?
Judge. We have 1 second.
Sure. Ladies and
Thank
gentlemen, why don't we just take a 5-minute break? Go in the jury room, don't discuss the case, we'll have you back out.
All right.
In a couple minutes. Thank you for your cooperation. All right, it's 10:19, the jury's in the jury room. We'll give state an opportunity to make sure the witness is available, rather than just have the jury sit here with no witness. I'll be right back out when you're ready. Before we bring the jury back out?
No, Judge, thank you.
State of the next witness?
We do, Judge. The state will call Richard Cicerone.
I'll just do that again in front of the jury.
Yep, thank you, Judge.
10:32, Corporal Bennett to bring the jury up.
Jury out.
All right, thank you, everyone. State's going to call its next witness. Ms. Linto.
Thank you, Judge. The state will call Richard Cicerone, please.
Yes, sir, good morning. Come on in. You could raise your right hand, face the court reporter. She will swear you in, sir.
You solemnly swear the testimony, swear or affirm the testimony you're about to give in this proceeding with the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Have a seat. Please state your full name and spell your last name.
Richard Cicerone, Cicerone.
Thank you, Ms. Linto.
Thank you, Judge. Mr. Cicerone, where do you work?
I work for the Division of Child Protection and Permanency at the Child Abuse Hotline.
And what are your responsibilities at the Child Abuse Hotline?
We field phone calls that come into the hotline where a caller may be making abuse or neglect allegations, and then we route them to the appropriate source.
Are you considered a screener?
Yes, I'm a screener there.
And are the calls that come into the Child Abuse Hotline recorded?
They're all recorded, yes.
Now, on April 2nd at 10:04 a.m., did you receive a phone call through the Child Abuse Hotline from a person who identified himself as Chris Gregor?
I did.
And did you engage in a telephone conversation with Chris Gregor?
I did.
And was this telephone conversation recorded?
It was.
I'm now showing you what has been marked S45A for identification purposes. And do you recognize that?
I do.
And can you tell the jurors what that is?
It's an audio recording from that date between myself and the defendant.
Okay. And what you have in front of you, that's actually a flash drive.
Correct.
And the contents of the flash drive are what?
The audio recording of myself and the defendant from that date.
Okay. Now, you reviewed that audio recording before you came to court today.
Yes.
And you're familiar with it.
Correct.
I'm now showing you what has been marked S45B for identification. Can you tell the jurors what that is?
This is a transcript of the audio recording from that date.
And before you came to court today, you reviewed that transcript and you compared it to the contents, the audio recording on S45A.
Correct.
And does that transcript accurately depict the recording that you previously had reviewed?
Yes, it does.
Your Honor, at this time, the state would move S45A into evidence, permission to play the recording. And we'd also ask that the transcriptions be distributed to the jurors as well.
Okay.
Thank you.
All right, so S45A is in evidence. Ladies and gentlemen, S45B is the transcript. As with the other transcript we had earlier in the trial, the transcript is merely an aid for you to follow along. If you believe the recording is different than the transcript, your conclusion as to what's on the recording controls. In addition, I have to give you an instruction with respect to this. S45A is for your consideration as a recorded statement allegedly made by Mr. Gregor. It is your function to determine whether or not the statement was actually made by Mr. Gregor, and if made, whether the statement or any portion of it is credible. You may consider all the circumstances surrounding the statement in making the determination with the following caution. I instruct you that in this case, certain portions of the recorded statement have been blacked out or not provided to you. You'll see that marking on a couple of pages of the transcript. You may only consider those portions of the statement which are being admitted into evidence, and you must not speculate as to the contents of the omission or the reasons for the omission. As always, I'll give you that instruction at the very end of the case as well. Please go ahead.
Thank you, Judge.
Good morning. You're reaching New Jersey Child Abuse Hotline. This call will be recorded for quality assurance. My name is Richard, Agent 1553. And your last name, how do you spell your last name?
Gregor.
And you call from an agency or facility today?
No.
And who's the child you're calling about? What's their name?
His name is Corey Micciolo, CoreyMicciolo.
And it was Corey, you said Corey?
Correct.
Okay, and what's his date of birth?
May 1st, 2014.
And what's your relationship to him?
His father, and he primarily resides with me.
And what's your address at home?
It's 900 Barnegat Boulevard North, Unit 903 in Barnegat, New Jersey.
What was the unit number?
903.
All right, and who else resides in your home?
Just my dog, my son, and me.
All right, and who is the mother to the child?
That is the person I'm calling about. Her name is Brianna, Breanna, same last name.
Same last name as Corey's?
Correct.
Okay, and where does she live at?
I'm unsure.
Do you have a phone number for her or anything like that?
I don't have it readily available, but you guys have been involved with us, so I'm sure that it's in the documentation somewhere.
Okay. All right, and what were the concerns today for the child?
So, essentially, his mother has put in an emergency application after filing,
For custody of the child?
yeah, so she essentially filed with the abuse allegation, which there's a worker that's actively involved. The worker came out to the house unannounced for the first visit, has discussed with my son privately what happened to the collusion that he had. My son had described that it was from football. Now, fast forward to yesterday, actually, it was this past weekend, my son's mother had she had an entire weekend, and she had called DTP on Friday. She called again on Sunday, which kind of made no sense in my mind, considering she had him that entire time. Nonetheless, now fast forward to yesterday. Yesterday, the DCP worker that we had been working with informed me that my son needed to go get an evaluation done within 7 business days, or 7 days, excuse me. His son's mother then decided that to take it upon herself during the 3-hour visit yesterday to take my son to the doctor, to the hospital, and she just went video silent, essentially from 7:30 until 1 o'clock in the morning. And I had no idea what was going on. She would not leave my son's side, and I was not able to be there for my son. And then furthermore, my son came back this morning, and he was stating to me that his mom said that he had to tell the doctor that I had hit him, and things of that nature, and coaching him. I tried to call a caseworker, but of course he's not answering. She said that the caseworker told her to disregard the visitation and to go to the hospital. So, which I imagine is not the case, considering we had up to 7 days to do so, that it didn't have to be done the same day and against a court order.
So I mean, I can tell you that even not knowing this case at all, it's not something that DCP would, restrict any sort of contact without any sort of documentation or court order involvement, kind of stating that. So that does not appear accurate. But I mean, And I can obviously note what you're telling me, and I know that the worker didn't answer. The worker is probably, well, the offices are closed today. So this information will get, passed on to a worker. That way they can see this information as part of the case. But no, there's nobody available at this point in order for you to speak to.
No, and I figured as much, but I wanted to document that my son had came home today after he was supposed to come home at 7:30 last evening. His mother refused to leave his house, so I was not able to be there for my son. And he said it was at the direction of DCP&G. And furthermore, the big issue for me is, she put in the abuse allegation and it said it to the worker twice. Once on Friday, once on Sunday, when the worker came back out. Now, after she had him for an extended period of time yesterday and had him at the hospital and was coaching him to say that I hit him, he said it. So my big concern is just, that her coaching is going to be disregarded and it's only going to be regarded in his statement.
And I'll definitely make note of what you're saying, and the worker has to take all things into account. And I obviously can't speak for how the case itself is going to be managed, but I mean, I will note everything that we're talking about and make sure that the worker gets a copy of it.
Yeah, because realistically, the worker has spoken to my son at my residence, and my son's very comfortable here, so there's no issues with that. And my son, I didn't even know the worker was coming. So even if I wanted to do something like she did and coach my son to say a particular thing, I had zero time to do so. Yeah. So, I just wanted documenting that he came home and one of the first things the first two things he said to me is, I don't want to go with my mom anymore. She's going to try to take me away from you. And then he also said that, mom told me to lie, I had to lie. And that was a huge concern of mine.
Yes, I'll definitely make notice. I do have some mandated questions to ask you about your household, as well as mom's household. And if you don't know the answers, you can just tell me that you're unaware.
Sure.
All right, what's the race and language of everybody involved?
White and English.
Any domestic violence, criminal history, or current substance abuse issues for anybody that you're aware of?
Not my household, their household, yes. The mother has significant substance abuse issues with methamphetamines, amphetamines, and heroin. And I actually am highly concerned that she's relapsing at this time.
What can you say that she's relapsing at this time?
She's acting very erratic, and it's extremely out of character for her, and there's no rationale behind it.
Any special needs, disabilities, or diagnosed mental health issues?
Well, also I wanted to state that the mother's sister, so my son's aunt, who by court order is not supposed to be around my son, is around my son, and she just got out of jail for drug charges. And then there's also the maternal grant. Sure.
Any indication that the aunt is using around the child, and what's her name actually?
Her name is Nicole, Micciolo, and last name. No indication that she's using around him, at least that I'm aware of.
And what were you going to say about the grandparent?
Maternal grandmother's boyfriend who also lives at the household is a two-time felon convicted felony assault. And he was by court order not supposed to be there as well, but he is every time my son is there.
All right, and related to mom's drug issues, I know you said that you believe she relapsed. Any indication besides her acting erratic and irrational? Like, did anybody say they saw her to be influenced, or any specific evidence of her using drugs?
Not specific evidence in that regard. Also, she started hanging around her ex-boyfriend who she was using with. She's been around my son as well, which is also against court order.
Any safety concerns in either home for a worker? Any vicious animals, weapons?
No, not I'm aware of.
Any child prostitution, pornography, or forced labor regarding anybody?
Not here, and not that I'm aware of over there.
Any international travel for anybody within the last 14 days?
No.
Anybody either having COVID-19 or suspected to have COVID-19? Anybody having any series of respiratory infections, cough, sore throat, anything like that?
No, but going back, I remember you asked a question about like mental disorders and things like that. The mother has PTSD from being bullied in middle school, and my son is diagnosed as emotionally disturbed. The classification he had when he lived with his mother based on the past aggressive behavior he showed, which does not exist anymore.
And I know that he's with you now. When is the next time he's due to see mom?
I believe it is next Tuesday.
What time do we know?
4:30 to 7:30, but knowing her, it will go over and she'll find an excuse to justify bringing the court order again.
And that contact that she has with him, when it happens, is it unsupervised?
Yes. Right.
All right, so this will go out to our Ocean South office. That way they have this information as documentation. Is there anything else I could do for you?
No, that's really it. I'm just, worried that if she coached him to say something, he came home and told me it, but, maybe it's going to be considered, and it's just a huge concern of mine. On top of everything else.
Well, and if everything does work out, I'll definitely make this notification.
All right, thank you. Have a great day.
You're welcome. Have a good night.
Mr. Cicerone, is that your voice on that recording?
Yes, it is.
And does that recording accurately depict your phone conversation with the defendant on April 2nd, 2021 at approximately 10:04 a.m.?
Yes, it does.
No further questions, Your Honor.
Thank you, Mr. Lucia.
How are you, Mr. Cicero?
Good, thank Thank you.
So, you work in a center, right?
Yes.
And you receive phone calls from different people during the day?
Yes.
And then it's your job to take the information, it's recorded as we see here, and then you pass it along, right?
Correct.
Now, do you have access at that time to any information about the case that the person is speaking to you about at your fingertips?
Yes, at that time.
Okay. So when Mr. Gregor is talking to you about her being directed, I believe it's on page 3 of 7, where he's telling you that she told him that she was to disregard the court order and go straight to the hospital, and you responded by saying that's something that DCP wouldn't do unless they had a court order, right, or something to that effect. Were you aware whether there was a court order at the time?
I was just making a statement for generally. I hadn't even looked really into the case to know about any history at that moment.
Okay.
So I was not aware there was or not a court order.
Okay. But it would be generally DCP&P's position as an employee there that they wouldn't make a recommendation like that unless they actually were told.
Objection, Judge, it's speculation.
Oh.
Well, based upon your experience and your knowledge, it would be speculation. Was that something in your experience and knowledge?
Can you repeat the question?
Within your job purview, is it known to you whether DCP&P would do exactly what you just said here, where you said, I can tell you that even not knowing this case, it's not something DCP&P, would you know, restrict any sort of contact without any sort of documentation or court order? Do you know that to be true?
So there are times where, not necessarily with a court order, but other plans that DCP&P may put in effect, which may restrict contact between a parent and a child. I didn't know in that specific case at that very moment whether that was the case or not.
So you were unaware at the time you were taking this call whether there was any restriction whatsoever?
Correct.
Now, how would you say my client's demeanor was during that phone call?
When I refer to the call, honestly, he presented information that was concerning for him relating to, we all heard the call, relating to concerns that mom was coaching the child. He seemed concerned about that.
Okay, he wasn't aggressive, right?
He was not aggressive.
He seemed like a concerned father.
Correct.
Nothing further, Judge. Thank you.
Can you redirect?
Did the defendant say on that phone call that he made at 10:02 that Corey was injured?
No, he did not say anything about it.
Did he say in that phone call that he made at 10:02 on April 2nd that Corey was sick?
No.
Thank you. Nothing further, Your Honor.
Anything else?
No, Judge.
Sir, thanks so much for coming in.
Yes, Judge.
Who's gonna?
The state would like to call Mike O'Hearn.
Hey, detective, come on up. Please raise your right hand. The court will ready to.
Do you solemnly swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole
Yeah.
truth, nothing but the truth?
Yes, I do.
Have a seat, please. You state your full name and spell it all.
Michael O'Hearn, and it's O''Hearn.
Thank you, Mr. Rowe.
Thank you, Judge. Good morning.
Morning.
Who do you work for?
Ocean County Sheriff's Office.
And in what capacity do you work for the Sheriff's Department?
I'm currently a sergeant assigned to the crime scene unit of the Sheriff's Department.
And when did you begin your employment with the Ocean County Sheriff's Department?
June 21st, 2004.
Just talk louder.
Sorry.
There's a lot of people in here.
I have allergy issue right now. Sorry.
I apologize. When did you begin your employment?
June 21st, 2004.
Okay. Did you have any law enforcement experience prior to your employment with the Sheriff's Department?
I was Class 2 in Beach Haven Police Department for a short time.
All right. And in order to become employed by the Sheriff's Department, did you have any specific training?
I went through the Ocean County Police Academy.
Okay. And did you continue training since you became a officer detective in 2004?
Yes.
Okay.
Once I was assigned to the crime scene unit, I attended a 6-week crime scene investigation course with the New Jersey State Police.
All right. And did you continue your training since then?
Yes.
All right. Could you give me some examples of the trainings that you've attended since then?
Yes. I've attended a medical legal death investigators course in St. Louis through St. Louis University. I've attended a basic arson course investigators through the Division of Criminal Justice. I attended a shooting reconstruction course, an advanced shooting reconstruction course, and there's various others.
Approximately how many investigations would you say you've been involved in since being assigned to the crime scene unit?
Say thousands.
And when did you get promoted to sergeant?
In 2018, May.
And I just don't remember, what year did you get assigned to the crime scene unit?
I was assigned to the crime scene unit February 22nd, 2011.
So from 2011 until your promotion, you were a detective there?
That's correct.
All right. And are you still assigned in the capacity of a sergeant today in
Yes.
that unit? All right. Did you become involved in the investigation into the death of Corey Micciolo?
Yes, I did.
All right. And what did you do in regard to your involvement?
On April 6, 2021, I responded to Alcoa Police Department in Alcoa, Tennessee, with Detective Capuano from CSI, Detective Purcell from Barnegat Township Police Department, Detective Mitchell from Ocean County Prosecutor's Office, in reference to a search of Christopher Gregor's vehicle.
And why did you do that?
To search the vehicle.
Do you know where the vehicle was located?
Yes, the vehicle was located at Alcoa Police Department's impound lot.
Do you know how it got there?
Yes, it was seized during a traffic stop.
Okay. And do you know who the operator of the vehicle was?
Yes, Christopher Gregor.
Okay. And do you know if anybody else was present?
There was a passenger with Mr. Gregor.
Now, when you got to Tennessee, was the defendant still with the vehicle?
No,
Did you have any personal interactions with the defendant?
I did not.
Okay. And did you meet with anybody from the police department in Tennessee when you were there?
Yes, Detective Vandergriff and Detective Waters from Alcoa Police Department.
And so when you got down there, what, if anything, did you do?
I photographed the vehicle and conducted a search and inventory of the vehicle's contents.
Okay. So you said you searched the vehicle.
Correct.
All right. And you inventoried the contents?
That's correct.
Did you document your inventory of the contents anywhere?
Yes, I did, in my report.
Okay. And did you actually take anything from the vehicle?
Yes.
Okay. Did you document that anywhere?
Yes, I did,
Where'd you document it?
in the report.
Okay. And among the things that you took from the car, were there any electronic devices?
Yes, there were.
All right. Could you tell us what, if any, electronic devices there were?
Yes, there was a silver thumb drive collected from the driver's side rear seat. There was a white thumb drive collected from passenger side rear door pocket. There was a drone underneath the driver's side, or passenger side front seat. And there was a LG track phone inside of the center console.
What is a track phone?
It's a prepaid cellular phone.
Did you seize those items?
Yes, they were collected into evidence.
Okay. And did you recover anything, did you and the detectives you were with recover anything from the members of the Alcoa Police Department?
Yes, Detective.
Well, I'm sorry.
Detective Vandergriff turned over 2 cellular phones to me that were seized during the traffic stop.
Okay. Did all of these items that you've talked about come back to New Jersey?
Yes, they did.
And you said you took photographs?
Yes.
Mr. 81, 82. Your Honor, may I approach the witness?
Sir.
Sergeant, I'm showing you what's been marked as S81 and S82 for identification. Do you recognize those photographs?
Yes, I do.
Are those photographs that you took in Tennessee on April 6th?
Yes, they are.
Okay, briefly, could you tell me what S81 is?
S81 is an overall vehicle, overall photograph of the exterior of the vehicle from the front.
Okay, and could you just, for our purposes, tell me what S82 is, briefly?
S82 is a picture of the rear passenger area of the vehicle.
Thank you. And with regard to S81 and S82, does the vehicle and the interior appear in these exhibits to be in the same or substantially the same condition as they were in when you were in Tennessee with the vehicle on April 6, 2021?
Yes.
Your Honor, permission to publish S81 and S82 and move them into evidence.
No objection.
S81 and S82 in evidence.
Ms. Lento, could you show S81, please? Okay, we're looking at S81. Could you please describe for the jury what is depicted in S81?
This is a picture of the exterior of the vehicle from the front view.
And S82, please? Could you please describe for the jury what's depicted in S82?
That is a picture of the inside of the passenger compartment rear of the vehicle.
And was this photograph taken before you began your search and inventory?
Yes.
Other than the involvement that you just described, did you have any other involvement in this case before or after the events on April 6, 2021?
No, I did not.
No further questions.
How are you?
Good, sir. How are you?
Good, thanks. So, you flew down there to process the car and to seize whatever evidence you can seize from the car?
That's correct. We drove, but yes.
Good. All right, you drove down there. And as part of your job as a CSI, you retrieved things from the car?
Correct.
Right, and you retrieved items, I believe it was 2 phones, were retrieved from Mr. Gregor and the individual he was with. Those were seized by Alcoa, Tennessee police at the time.
That's correct, sir.
And they took it, and then they handed it to you, and you vouched it the way you would vouch for it, I'm assuming?
Yes, I submitted it to evidence for chain of custody.
And then you brought it up here?
Correct.
Okay. Now, in addition to seizing items that you thought, the phones, the thumb drives, by the way, the 2 drives you found, were they labeled in any way?
I don't recall, sir.
Would it be in your report?
No.
Okay. So, did you also process the car to see if there was any evidence in the car?
Yes, sir.
Okay. Did you find any blood evidence in the car?
No, sir.
Okay. Did you find any children's clothing in the car?
Any children's clothing? I don't recall. I'd have to review my inventory.
Do you have that?
I don't have a copy of my report, sir.
Did you receive anything when you processed the car of evidentiary value?
Yes.
Would you receive?
From the car? We collected the electronic devices. There was a bottle of GNC niacin pills from the passenger rear door compartment, and there was a track and field pole and a baseball bat.
Okay. And you took all those and processed them, and then you sent them to the lab?
Yes, sir.
Okay. Do you know if the lab processed those items?
No, sir.
No further questions, Judge.
Thank you. Any redirect?
No, thank you.
Detective, thanks for coming in. Sorry.
Thank you.
Do you have another witness available?
I do. I just wanted to set some things up on the table because I have quite a few exhibits.
Sure.
It won't take me very long.
You want to take a brief recess?
I'll defer to the court.
I'd rather have you go back in the jury room for a couple of minutes, ladies and gentlemen, while everyone gets ready. So thank you for your patience. We'll have you back out.
All rise.
Jury room, can I see counsel at sidebar?
Yes.
Can be seated.
Is it okay if I move this stuff? All right, wait.
Late, I read a limiting instruction regarding the redacted recording. Madam Clerk, I ask you to mark that as Exhibit C next in order. We had a sidebar conference after that witness, and amongst other issues, discussed that Sergeant O'Hearn had testified that he had went to Tennessee and met with the defendant, among other things, Mr. Galucci, previously marked as Exhibit C4, a charge on alleged flight. You want me to read that to the jury now after Sergeant O'Hearn's testimony?
Yes, Your Honor.
All right, so we'll bring the jury back in. I'll read that instruction, and at that point, state can call its next witness.
Okay, thank you, Your Honor.
11:10 a.m. Jury out, please.
All rise. Jury out.
Thank you. Please be seated. Ladies and gentlemen, before we hear from the next witness, I have to give you an additional instruction. There's been some testimony in this case from which you may infer that the defendant fled shortly after the alleged commission of the crime. The defendant denies that his acts constituted flight. The question of whether the defendant fled after the commission of the crime is another question of fact for your determination in this case. Mere departure from a place where a crime is being committed does not constitute flight. If you find the defendant fearing that an accusation or arrest would be made against him on a charge involved in the indictment, took refuge in flight for the purpose of evading the accusation or arrest on that charge, then you may consider such flight in connection with all other evidence in this case as an indication or proof of consciousness of guilt. Flight may only be considered as evidence of consciousness of guilt if you should determine that the defendant's purpose in leaving was to evade accusation or arrest for the offense charged in the indictment. There has been some testimony in this case from which you may infer that the defendant fled shortly after the commission of the crime. The defense has suggested the following explanation, namely that the defendant was being threatened. If you find the defendant's explanation credible, you should not draw any inference of the defendant's consciousness of guilt from the defendant's departure. If, after consideration of all the evidence, you find that the defendant, fearing that an accusation or arrest would be made against him on the charge involved in the indictment, took refuge in flight for the purpose of evading the arrest or accusation, then you may consider such flight in connection with all other evidence in this case as indication or proof of consciousness of guilt. If you as judges of the facts, it is for you as judges of the facts to decide whether or not evidence of flight shows a consciousness of guilt and the weight to be given to such evidence in light of all the other evidence in this case. As always, I'll read that instruction to you as part of my final charge as well. We'll continue with the state's next witness.
Thank you, Your Honor. The state would like to call Raymond Coles.
Raymond Coles. Hi, Sergeant, come on.
Thanks, sir.
You could raise your right hand. The court will swear to answer.
Good morning.
Do you solemnly swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Have a seat, sir.
Thank you.
Please state your name and spell your last name.
My name is Raymond Coles, C-O-L-E-S.
Ms. Strong.
Thank you, Your Honor. Sergeant Coles, if you can, because we have a court reporter today, just speak slowly enough that she can transcribe what you're saying, so we're not just being audio recorded. I have a habit of doing that, too.
Yes, ma'am.
Thank you. So where are you currently employed?
I'm currently employed by the Ocean County Prosecutor's Office.
In what capacity are you employed there?
I'm the sergeant of the Digital Forensic Laboratory.
And how long have you worked for the prosecutor's office?
I was first hired by the prosecutor's office in July of 2014.
And what different roles and assignments have you held while employed at the prosecutor's office since then?
So when I first started working at the prosecutor's office, I was assigned to our grand jury unit, basically putting together grand jury discovery packets to go out for court proceedings. Did that until I went to the police academy as a detective in January of 2016. I maintained that role once I graduated the police academy until June of 2017 when I was transferred to the high-tech crime unit.
What does a detective or now a sergeant assigned to the high-tech crime unit actually do?
Sure. So we, high-tech crime unit used to be composed of both an investigation component and a forensic analysis component. In October of 2023, we split the unit into specifically a forensic laboratory, and then we have a subunit that does investigations separately. So what I do is, in addition to continuing to conduct forensic examinations of devices such as cell phones, computers, digital video recorders, car infotainment systems, and other Internet of Things devices, I also supervise the other case detectives or the other detectives in my unit, as well as my civilian analyst. I assign cases, and I also help maintain our ISO 17025 accreditation for American Association of Laboratory Accreditation.
Is that any different than what you used to do before the unit was divided into a lab and then an investigations unit?
So prior to the unit being split, I primarily dealt with the digital forensic examinations of devices seized for criminal proceedings.
When were you promoted to a sergeant?
In October of 2023.
Could you give the jury the benefit of your educational experience?
Sure. I have a bachelor's degree from LaSalle University, in which I graduated in 2013.
All right. Do you have a CV?
I do.
All right. And would the CV help you explain what trainings you've had during the course of your career?
It would.
Your Honor, permission to approach the witness?
Yes, sir.
And Your Honor, I'm going to need to show the witness a number of things. Permission to approach throughout his testimony?
Right, you don't have to keep it.
Thank you, Your Honor.
Thank you.
Could you tell me, I'm showing you what's been marked for identification as S119. Could you tell me what that is?
S119 is my CV.
Now, before we get to that, can you please explain to the jury what the field of digital forensics actually is?
I can. So generally, digital forensics is going to come down to two components. The first component is going to be the acquisition of devices, such as creating an image of a computer hard drive or doing an extraction of a cell phone. The second component of that is going to be processing those extractions within computer software and analyzing the contents of those devices.
What, if any, classes specific to digital forensics have you attended throughout the course of your career?
Sure. The most recognized course that I've been to was the IASIS. That's the International Association of Computer Investigative Specialists, the Basic Computer Forensic Examiner course. That was a 2-week-long course down in Florida. Once that course completed, there were 4 coach problems that require approximately 3 to 4 weeks to complete. Once those 4 problems are completed in succession, you then take a independent practical examination followed by an independent knowledge-based assessment. I passed that and received my IASIS Certified Computer Forensic Examiner certification in October of 2018.
Any other significant certifications or trainings that you held or have attended throughout the course of your career pertinent to digital forensics?
Sure. A few years ago, I took the IASIS Mobile Device Examiner course. It again was a week-long course that I took online. That course ended with a knowledge-based and practical assessment, in which I also successfully passed that and received the IASIS Certified Mobile Device Examiner. In addition to IASIS, which would be a vendor-neutral certification, I also have specific vendor-specific certifications. Most notably with Celebrite. Celebrite is an Israeli company, and they have a program, or 2 programs. One is called Celebrite UFED 4 PC, which stands for Universal Forensic Extraction Device. The second is Celebrite Physical Analyzer. The Celebrate UFED 4PC was covered in what's been known as the Celebrate Certified Operator course, or the CCO. The Celebrate Physical Analyzer was covered in the CCPA course, which is Celebrate Certified Physical Analyzer. In addition to those, I have vendor-specific certification from Magnet Forensics for the Axiom program, which is another program that's used to parse artifacts from computers and cell phones. And I have the MCFE, the Magnet Certified Forensic Examiner. Just to go back to the Celebrate real quick, Celebrate has their capstone certification for cell phone examinations known as the CCME. That's the Celebrate Certified Mobile Examiner, and I believe I obtained that in October of 2020. Additionally, I have certifications from a company called Burla. Burla is designed for vehicle infotainment systems. So if you've ever seen, your car GPS or getting text messages through your car, Burla goes through the process of acquiring that from your mobile vehicle, as well as parsing out the artifacts in the program called IVE, or IV. In addition to those certifications, I've also partaken in proficiency testing or external proficiency testing through a company called Collaborative Testing Services. We do that as part of our laboratory accreditation, in which I've taken the proficiency examinations, and my answers were deemed to be consistent with what other examiners across the country were identifying.
You had said that you assisted with the lab accreditation. Is the lab's accreditation presently current?
The lab's accreditation is currently active, yes.
Okay.
We're being reassessed later this year.
Now, you also mentioned terms vendor neutral, vendor specific. What do you mean by that?
Sure. Vendor neutral is going to be, they don't have the tool themselves. They're just going across fundamentals. They might use multiple different tools to highlight different ways to acquire or look through data. A vendor-specific class is going to be using the vendor-specific tool. And, you might use additional tools to verify and validate artifacts covered from the vendor's tool to show you that, hey, look, our tool works.
And in addition to all of that, did you also attend the Ocean County Police Academy?
I did not attend the Ocean County Police Academy.
Which police academy did you attend?
I attended the Division of Criminal Justice Basic Course for Investigators in Seagirt, New Jersey.
When was that?
That was from January of 2016 until June of 2016.
And did that include more basic teaching about policing, not all of the specific training that you've done?
That was a more basic police investigations. Included standard physical training and defensive tactics. It was more emphasis on investigations as opposed to patrol responsibilities that a patrol officer would experience or encounter.
Are all of your certifications that you just named current?
They are.
Are you employed by anyone other than the Ocean County Prosecutor's Office?
I've been hired as an independent contractor for Celebrate to teach the CCO and CCPA classes, along with the CMFF, which stands for the Celebrate Mobile Forensic Fundamentals course.
And what type of training or certifications did you need in order to get that position?
The key requirement was to maintain the Celebrate Certified Mobile Examiner certification. I put down my resume to them when they were looking for more contract trainers. I went through a panel interview where I presented a lesson. They liked how I presented a lesson and let me attend their instructor development course. Once I completed the instructor development course, they do what's known as a shadow teach, where I teach the class in front of a master trainer or one of their senior trainers or members of their training staff, in which I'll present the course. If they like how I present the course, they would then let me stay on as a level 1 certified contract trainer.
And is that what you serve as for them now?
It is, yes. I went through my shadow teach in June of 2023, and I've currently taught 3 different weeks of classes for them, using my personal time away from the office.
And where have you done that?
The first one where I did the shadow teach was in New York at the Manhattan Attorney General's office. The second one was out of Iowa, and that's where we did a CMFF, the Celebrate Mobile Forensic Fundamentals course, paired with a CCO, a Celebrate Certified Operator course. And earlier this year, I went down to Vienna, Virginia, and taught the Celebrate Certified Operator and Celebrate Certified Physical Analyst course.
In the course of your career, could you approximate the number of digital forensic examinations that you've done while assigned to the prosecutor's office's high-tech crime unit?
Sure. So I've been assigned over 800 forensic investigations to do. Of those 800 cases, roughly 3,000 devices, I've processed roughly 3,000 devices within the laboratory.
When you use the word device,
Mhm.
what does that encompass?
So a device can be any digital media that's turned over to us, whether that's a hard drive that was found in somebody's room, a flash drive, a cell phone, a vehicle infotainment systems we spoke about earlier. Any electronic digital media turned over to our laboratory would be considered a device.
Approximately how many of those investigations that you've been involved in involved the use of Celebrate software?
Sure. Most of the forensics that we get assigned involve cell phones today. I don't have an exact ratio. I would say maybe around 80% all involve cell phones. Every single time I process a cell phone, I'm processing that cell phone within the Celebrate physical analyzer software. Depending on the type of phone or the extraction I'm looking for, those extractions will be obtained through the UFED 4PC software.
I know that you told us a little bit about what Celebrate is as a company, but could you explain more of how it works?
Sure. So the extraction tool will work with the device, input a set of commands to the phone itself, and use that to then extract the data from the phone to a local computer or whatever you're setting the extraction to. There's different formats. There's like the UFED Touch, which is more of like a tablet-based tool where you can extract to a computer or a hard drive. And then you have the Celebrate UFED 4PC, which works off of a computer. We save those extractions directly to our forensic computers in the laboratory. Once those extractions are processed, they go through a process known as hashing. A hash is essentially going to be a digital fingerprint of that electronic media file. It's a mathematical algorithm that will set a fixed, using an MD5, a fixed 16-byte number, where if you change just one letter in that extraction, it'll generate a radically different value. So the hash is going to essentially create a fingerprint so I can know that that data is in the original state that it was obtained in. Once the extraction is conducted, we'll then process that extraction within the physical analyzer software. Once you're going through that software, it'll categorize different artifacts for you to kind of sift and sort through. It'll break down artifacts into contacts, call logs, messages. It'll subcategorize messages between different third-party or native applications on the device. So you can see messages from regular, iMessages or SMS messages from an Android phone. You might see third-party apps broken down, such as Facebook Messenger or WhatsApp. It'll break down media files to sort through images, videos, or audio files. You can search through web history, user accounts, user passwords. In addition to that, you could also filter through what's known as a timeline view, where you can see the raw output in chronological order for every activity happening on that device for a set date range. If you get more advanced, there's more advanced tools you can use within the software, such as going through the actual databases themselves and looking at the data, how it's natively stored on the device. You can use additional carving tools to try to recover additional data. And there's some other tools that you can use if you really want to get into the weeds.
Is this software available to anyone or just you?
It's publicly available software that anyone can acquire a license and utilize the software. Or I won't say anyone, but they will most likely, I believe some countries are not sold to, but most people in the U.S. trying to acquire it should be able to acquire it.
And in order to view these extractions, is there certain software that a person would need?
Sure. So if you wanted to view the phone extraction through Physical Analyzer, you would need a software license, or we call it a dongle, which is basically like a USB drive that plugs into the computer. You would need that in order to access the device or access the extraction. What Celebrate has is known as a Celebrate Reader, which is a portable light version of the Physical Analyzer software that does not require a license to use. Generally, when we receive a device in the laboratory, we will generate that Celebrate Reader report and pass it off to the case officers so that they can kind of go through and find what they're looking for.
You had described the analysis that you do and the creation of certain reports. Are those separate aspects of what you do using Celebrate?
It is.
And do you use any other software to assist you commonly with digital forensic investigations?
So we had spoke about Magnet Axiom before. In addition to the Celebrate software, we have another tool in the laboratory called GrayKey, which can help with the extraction of Apple iPhone devices. At the time of this investigation, I believe it was only iPhones. But today you can also acquire Android-based devices as well.
Why would you need GrayKey?
At the time, Graykey could obtain a deeper extraction of the device than what was possible through the UFED 4PC software. And by deeper extraction, I mean it could obtain what's known as a full file system extraction, where it obtains the entire file system on the device. Best way to think of a file system is if you've ever been on a Windows computer and you click on the local disk C and you see all the little files and folders in that hierarchical structure. It'll allow you to kind of go through the actual phone in that capacity.
Have you ever been qualified as an expert in digital forensic examination in the state of New Jersey or any other jurisdiction?
I've been brought in as an expert within the Ocean County courthouse, approximately for 5 criminal cases, including motions where I brought in separately. I've been qualified as an expert about 10 times.
Your Honor, at this time, the state offers Sergeant Raymond Coles as an expert in the field of digital forensic examinations and analysis. No objection.
All right, ladies and gentlemen, it's my function to give you an instruction. I'm going to grant the state's application for Sergeant Coles to testify as an expert witness in digital forensic examination. As a general rule, witnesses can only testify as to facts known by them. This rule ordinarily does not permit a witness to express an opinion and let it be received in evidence. However, an exception to this rule exists in the case of an expert witness who may give his or her opinion as to any matter in which he or she is versed, which is material to this case. In legal terminology, an expert witness is a witness who has some special knowledge, skill, experience, or training that is not possessed by the ordinary juror, and who thus may be able to assist the jury in understanding the evidence presented and determining the facts in the case. In this case, Sergeant Coles is being called as an expert witness in digital forensic examination by the state. You are not bound by any such opinions he gives, but you should consider each opinion and give it the weight to which you deem it is entitled, whether that be great or slight, or you may reject it. In examining each opinion, you may consider the reasons given for it, if any, and you may also consider the qualifications and credibility of the expert. It is always within the special function of the jury to determine whether the facts on which the answer or testimony of an expert is based actually exist. The value or weight of the opinion of the expert is dependent upon and is no stronger than the facts on which it is based. In other words, the probative value of the opinion will depend upon whether, from all the evidence in this case, you find that those facts are true. You may in fact determine from the evidence in this case that the facts that form the basis of the opinion of the expert are true, are not true, or are true in part only. And in light of such findings, you should determine what weight to be given to the opinion of the expert. Your acceptance or rejection of the expert opinion will depend, therefore, to some extent, on your findings as to the truth of the facts relied upon. The ultimate determination of whether or not the state has proven the defendant's guilt beyond a reasonable doubt is only to be made by the jury. As always, I'll give you that expert instruction part of my final charge. Thank you. Ms. Trump.
Thank you. Sergeant Coles, did you become involved in an investigation surrounding the death of Corey Micciolo?
I did.
Do you recall when that was?
It was in April of 2021.
Now, in association with that, did you prepare written reports?
I did.
Did you prepare notes?
I did.
Would your ability to have those reports and notes in front of you while you testify aid you today?
They would.
I'm showing you what's been marked for identification as S116, 117, and 118. Could you please tell me what S116 is?
S116 is an analysis report in regards to specific questions that were posed to me by the state when they were reviewing this case.
Could you tell me what S18 is?
S18 is the generic report describing the extractions of the devices that were conducted and the evidence in this case.
And could you tell me what S17 is?
S117 are the notes associated with the initial report. Just to go back, the initial report was CF 210081.
What is that? What's the significance of that?
That is our internal laboratory number for that case.
And all of those are multi-page reports?
They are.
Now, as part of your involvement, did the high-tech crime unit participate in the collection of video evidence from anywhere?
We did.
Where?
So the first video that we pulled in this investigation was from the Atlantic Heights apartment complex in Barnegat, or townhouse complex in Barnegat. And the second one we assisted with partially was the Southern Ocean Medical Center.
With regard to the Atlantic Heights apartment complex, could you tell me when that occurred and how it came about?
Sure. We were requested to go out there on April 3rd, and we were requested to pull all surveillance video from the system from March 20th to April 2nd of 2021.
Did you do that?
We did. So in this case, it's a fairly large range of video to request to be pulled. If we were to use the internal export through the DVR itself, something like that, exporting to flash drives would take a very, very long time. In this case, we actually took the hard drive out of the DVR. We lent them a loaner drive so their system continued to work. We transferred their drive to the Digital Forensic Laboratory. We hooked that up to what's known as a forensic write blocker to prevent any reader writes to the original source media. We then scanned that disk with a program called DVR Examiner, which then scans through the file system of the digital video recorder and identifies all the clips on that device. The clips in the date range were then exported out into an MP4 format so that the case officers could review the files that they were looking for.
Based upon the investigation, were you able to identify a time frame of significance?
Yes, it was identified on March 20th at approximately 4:20 or 4:18 p.m. We identified Mr. Gregor and Corey Micciolo inside of the gym facility at the apartment complex.
Did you ever obtain any other surveillance from the gym complex?
We did. So in July of 2021, the Barnegat case officer on the case had requested us to burn all video from the gym camera off that system. So what I did is, after we had processed the video from the initial extraction, we created what's known as a forensic image of the DVR hard drive, which is going to be a bit-for-bit copy of the entire drive saved to our forensic computer in the laboratory. I loaded that forensic image into the DVR Examiner program again in July and exported all the video obtained from that. So I believe the clips went back to about January 30th of 2021.
Did you provide that video or information to the case detective?
It was.
And did that include just the gym or other views?
The second export just contained the gym footage.
The first one did
contained all cameras.
Are you familiar with the term time offset?
I am.
What does time offset mean?
So time offset is going to be the distance of time between the actual accurate time value versus what's being displayed on the device's user interface or device's screen.
And are you aware if the term time offset applied to the footage that you said you received from March 20th, 2021? I think you said it about 4:18 p.m.
Yes. So what we normally do is we'll take a picture of the, kind of like the home screen where you see all the different camera views. From that picture, we'll make sure the timestamp is recorded in the photograph. We'll then compare the metadata of the photograph we took, which has a known accurate time value if we use our phones on a cellular network. And then I'll compare the offset that way. In this case, the DVR was approximately 2 seconds slow.
I'm showing you what's been marked as S18, A, B, C, D, already in evidence and already published to the jury. Do you recognize what that is?
I do. It's a USB flash drive.
Okay. Do you know what's on it?
Specific 4 videos exported from the DVR that were provided to the case officer.
Have you reviewed them prior to coming to court today?
I have.
And is it a copy of the same footage that you reviewed from the time frame that you identified?
It's an exact copy of the exported video.
Thank you. In addition to the surveillance from Atlantic Heights, did you recover footage from anywhere else? I think you said Southern Ocean Medical Center?
I did. So we were requested to get video from Southern Ocean Medical Center. The security staff would not let us pulled video footage ourselves, most likely due to HIPAA violations where we might get other patients in there. So we provided them with legal authorization, and they then burned the requested time frame, which was when Mr. Gregor arrived to the hospital with Corey and when Mr. Gregor left the hospital.
Do you remember when you obtained that?
I believe the video was initially provided on April 5th, but when they gave us the DVDs containing the footage, only one of the 9 DVDs actually had footage on it. The rest of the DVDs just contained hyperlinks to files themselves. Since the videos weren't saved on the actual DVDs, the hyperlinks would not open any files. We contacted them and obtained a second copy of the videos that then worked, I believe on April 8th.
So just to clarify, you provided the hospital with a time frame of significance?
We did.
Okay. And the hospital chose the surveillance footage?
They did.
And provided it to you?
They did.
All right. I'm showing you what's been marked as S48A, B, C, D, E, F, G, H, I. I think there's 9 of them. Could you take a look at them?
Yes.
And do you recognize all of those discs?
Yes, they're DVDs that or CDs that contain the provided footage from the hospital.
Did you review those before coming to court today?
I have.
Are they exact copies of what you received from the hospital when you recovered the footage, I guess, the second time when it was correct?
They are.
Now, with regard to time offset that you described earlier, does that apply to these as well?
So these videos were identified, the time on these videos was identified not to be accurate. So it does apply.
Were you able to determine the time set with respect to the time offset with respect to any of those videos?
I did, specifically exterior camera. What I did in this case is I compared location data recovered from Mr. Gregor's iPhone, which was consistent with him pulling up to the hospital. I compared the timestamp of the location data with the timestamp in the surveillance video and identified the exterior camera was approximately 3 hours and 3 minutes fast.
Does that apply to S48A and I?
Yes, it does.
Your Honor, permission to admit and publish S48G, H, and I.
Any objection?
No, Your Honor.
S48G, H, and I in evidence.
Your Honor, may I please sit down just for a brief moment so I can operate the computer?
Sure.
Thank you. Sergeant, I'm showing you what's been marked as S48G. Sergeant, are you aware if the timestamp on that video is correct?
Again, I believe it's off by a few minutes.
Showing you what's been marked as S48H. Are you aware if the timestamp on that video is correct?
I'm not.
And next, showing you S48I. Are you aware if the timestamp on that video is correct?
That one's not. That video is going to be 3 hours and 3 minutes fast. In this case, I also have location data from his phone. I noticed that he was on his cell phone when he was walking out of the building. I identified that he had a call log, I believe, to his father at 5:20 p.m., which would be that 3 hour and 3 minute offset.
So that was approximately 5:20 p.m.
Yes, it was.
In addition to completing the collection of video that you just described from Atlantic Heights and the Southern Ocean Medical Center, was the high-tech crime unit asked to complete full device extractions on any cell phones?
We were.
I'm going to show you what's been marked as S124 for identification. And instead of walking back and forth, I'm also going to show you what's been marked as S125 for identification. Could you just take a look at those, please? First, with respect to S124, do you recognize that picture?
I do.
What is that a picture of?
This is a picture of Miss Micciolo's Samsung Galaxy A10e smartphone.
Brianna Micciolo?
Brianna Micciolo.
And do you know if there's a phone number associated with that phone?
I do. Top of my head, I'm just going to look at the report that I have here. The phone number on that phone is 732-912-6711.
Did the phone depicted in S124 come into the possession of the high-tech crime unit?
It did.
Do you know when that was?
It was April 3rd of 2021.
And do you know what the purpose was of taking possession of the phone?
To conduct a full device extraction in order to search for any evidence related to the death of Corey Micciolo.
And do you know who provided the phone to the high-tech crime unit?
I believe the phone was turned over by Detective Joseph Mitchell from the Ocean County Prosecutor's Office.
Did anyone in your unit make any efforts to examine the data contained on that device?
They did.
Okay. And could you explain how that was done?
Sure. So the device we got initially, we did what's known as a full file system extraction of the device. This type of device uses what's known as file-based encryption. A full file system extraction is the highest level of extraction possible for this type of device. That extraction was conducted utilizing the UFED 4PC software we had spoken about, and then the extraction was processed within the Celebrate Physical Analyzer software. The full decoded results of the extraction were generated into the Celebrate Reader report, which was provided to the case officers for their review.
Were you able to ultimately review and analyze that extraction?
I did.
And were you able to determine if that actually came from Brianna Micciolo's Samsung Galaxy?
It did, yes.
How were you able to do that?
Sure. Easiest way is to look at user accounts on the device and see different user accounts for different third-party applications that has her name on it. The device phone number matched the reported phone number that was belonged to Ms. Micciolo. And when I looked at it, again, it was labeled with our case number, which is the CF210081, specifically item number 1. And that's how it was stored in the folder, and that's where it was when I got it.
With respect to S125, do you recognize that?
I do.
What is it?
It's a picture of Mr. Gregor's Apple iPhone.
And is there a phone number associated with that phone?
There is.
Could you tell us what it is, please?
Sure. The phone number on this device was 60.
Aware of what model iPhone that is?
It's an Apple iPhone 11.
And how did that come into the possession of the high-tech crime unit?
It was turned over to us by Detective Dennis Mitchell of the Ocean County Prosecutor's Office.
Do you know when that was?
I believe it was turned over on April 8th. Yeah, April 8th.
And do you know what the purpose was in the high-tech crime unit taking possession of that phone?
Yes. The purpose of this device was, again, to conduct a extraction of the device in order to search for evidence related to the death of Corey Micciolo.
Now, did anyone make any efforts to examine the data contained on that device?
They did. So initially, when we processed the extraction, we provided the full extraction to the case officers they review. Later on, I reviewed the contents of that phone extraction.
Do you know how that was done?
So in this case, we utilized the tool called Gregor, which could obtain the deeper extraction of an iPhone to get us that full file system extraction. Just like the Samsung phone before, the Apple iPhone 11 utilizes file-based encryption. The full file system extraction is the highest possible extraction to be done on this device that's possible. Once that extraction was conducted, it was processed within the physical analyzer software, and again, those results were generated into a separate reader report.
With regard to both phones that you talked about, did you have passcodes for them?
We did.
And did you ultimately review and analyze the extraction that came from S125?
I did.
And were you able to determine if the extraction that you reviewed actually came from that phone?
I did.
How did you do that in that case?
In the same manner for different Ms. Micciolo's phone. Compared the known phone number that was reported to be his phone number was taken from his person, and user accounts, or his vehicle, I'm not sure, and user accounts associated with him were turned over to us, or identified on the device that was turned over to us.
I think that you explained this earlier with regard to how an extraction is divided up in the reader. Would that explanation apply to this cell phone extraction?
It would.
Now, if you were to print the extraction from this cell phone, the defendant's cell phone, approximately how many pages would that be?
91,000.
And if you were to print just the text messages from the defendant's iPhone 11, how many pages would that be?
About 15,000.
Now, how much of the defendant's cell phone extraction did you review from April 1st of 2021 through April 4th of 2021?
Sure. I looked through all web history, all chats, whether it be from native chatting applications, third-party chatting applications, call logs, media files. So the standard areas that anyone looked through.
Did you review any other portions of the extraction from the defendant's cell phone?
We did. Some of the chat threads, specifically between the April 1st to April 4th range, began well before April 1st. So in addition with those, reviewed some of the artifacts, reviewed some of the chat messages prior to, call logs prior to.
And did you review other artifacts from March of 2021 in that phone?
Yes.
Now, as a result of your review, were you able to isolate certain items like calls and photos, text searches contained within Ms. Micciolo's phone and the defendant's iPhone 11?
I did.
Now, could you explain exactly what an artifact is?
Sure. So an artifact essentially is going to be a specific entry in that device. So if you have a call log, May 7th, 2024 at 12 o'clock, that one call would be one artifact. Say you had a text message yesterday. That text message by itself would be one artifact. If you wanted to group all text messages together from one conversation, you could either consider the conversation itself to be an artifact or every single individual message in that conversation to be an artifact. So basically, an artifact is any individual entry identified within the extraction.
Actually, Council Sidebar, before you go further. Ladies and gentlemen, I apologize for the interruption. We're going to continue with the testimony. Ms. Schramm.
Sergeant Coles, I'm showing you what's been marked for identification as S123. Could you take a moment and review S123? Do you recognize it?
I do.
Could you explain to us what S123 is?
This is an excerpt of call logs taken from Mr. Gregor's Apple iPhone 11.
Could you tell us how that was created?
Sure. So in this case, this is not the entire call log on the device for this date range. Specific entries were checked and then exported into a PDF report.
So those are excerpts of phone calls.
That's correct.
And what type of information is available from a call log like S123?
Sure. You'll see whether the call was incoming or outgoing, the party the call was connected to, the date and time of that call, the duration of the call, and the status of that call as well.
Do you know where those call log excerpts came from on S123?
From the actual file system of the phone itself, or
Whose phone?
Mr. Gregor's.
Okay. And sure, from the file system itself.
Sure. So the directory would read as private/var, VAR, /mobile, /library, /call history DB, and then inside of that you have a file called the call history.storedata, which stores the call logs on an Apple iPhone.
Is there a date and time range indicated on S123?
Sure. The first entry on here is April 1st, 2021 at 4:36 p.m. And the last entry on here is April 2nd at 5:25 p.m.
Now, with regard to the phone numbers listed on S123, were you able to determine who they belong to?
I believe so, yes.
Do the phone calls listed on S123 accurately depict the information that you got in the call log on those selected phone calls?
They do.
Your Honor, permission to admit S123 into evidence and have the witness describe it to the jury. No objection.
S123 in evidence.
Could you take us through the call log and go selected call by selected call through S123, including who the caller is, who the receiver is, date, time, duration, everything that you described?
Sure. The first call on here was from the number 1-201-317-0741. Identified to belong to Mark, I believe Wojciechowski from DCP&P. That call was on April 1st, 2021, at 4:36:10 p.m. Again, that was an incoming call. The call lasted for 3 minutes and 44 seconds.
When you say incoming call, what do you mean?
It was a received call on device. It was not an out. If an outgoing call would be me calling you, an incoming call would be you calling me. Okay. Assuming we're working with my phone.
And you just said the time. Are you familiar with the term UTC?
I am.
Could you please tell us what UTC is?
So UTC is going to refer to Universal Coordinated Time. Essentially, UTC is going to be the time along the prime meridian in Europe, which is going to be 0 UTC. All other time zones are based off of that time zone. Eastern Standard Time is 5 hours behind UTC. When we spring forward during daylight savings time, we spring forward, so -5 + 1 would be -4. So therefore, during Eastern Daylight Time, we are 4 hours behind UTC.
All right. So if it is 12:07 p.m. now, what would that be in UTC?
4:07.
And the times that you're giving are automatically adjusted to our time zone.
That's correct. So when you're dealing with the phone extraction itself, majority of the time in the databases, the date and times are going to be stored in UTC. The Celebrate software is converting it to our time, since that was the identified time zone on Mr. Gregor's phone. And you can change it to different time zones, depending on what you need for your investigation or analysis.
What happens if that phone goes into other time zones?
So those time zones, again, every time is in UTC. So it'd be automatically converted to show us in our time zone. So if a time happened at a different time, it would just be an hour. If we went west, it'd be an hour slower on ours.
Could you please continue with S123?
Sure. The second entry is going to be another call log from Mark from DC and PMP, the 120. This is another incoming call on April 1st, 2021 at 5:26:49 p.m. Eastern Daylight Time. And from now on, all these will be in Eastern Daylight Time. It's easier to say. The call lasted for 1 minute and 53 seconds.
Please continue.
The third entry is another call log from Mark from DC PMP, 201-317-0741. This call was on April 1st, 2021 at 7:24:48 p.m. And that call lasted for 1 minute and 27 seconds.
Was that incoming or outgoing?
That was an incoming call.
Please continue.
Next call was an outgoing call to Brianna Micciolo, 732. Call went out on April 1st, 2021 at 7:27:05 p.m. and that call lasted for 37 seconds.
Please continue.
The next call was another outgoing call to Miss Micciolo. Lasted for 1 minute and 12 seconds.
Please continue.
Just real quick, do you want me to read the entire phone number with the name, or if we have a name associated, would it be easier just to read the name?
I would ask that after you've already testified to who the phone number is associated with, you could please recite the name as it's saved in the contact in the phone.
Sure.
No objection to that, Judge. That's fine. Please do that.
And if there's no contact saved in the phone, do you want to just read the phone number, or if we know who it belongs to, just to say the contact?
You can read the phone number and who it belongs to, please, in that instance.
Sure. Okay. The next call in this entry is another outgoing call to Brianna Micciolo, or Brianna M. The phone call was on April 1st, 2021 at 8:42:02 p.m., and this call lasted for 1 minute and 12 seconds.
Please continue.
The next outgoing call is to the number 732. It belonged to the Neptune Police Non-Emergency Line. That call was sent at April 1st, 2021 at 8:43:45 p.m., and that call lasted for 38 seconds.
And when you say sent, does that mean outgoing?
It does.
Next one.
The next outgoing call is again to the 732, which is going to be the Neptune Non-Emergency Line. That call was on April 1st, 2021 at 8:44:32 p.m. That call lasted for 5 minutes and 36 seconds.
Please continue.
The next outgoing call was to the number 7. Jersey Shore University Medical Center in Neptune, New Jersey. That call was on April 1st, 2021 at 8:51:19 p.m. and that call lasted for 10 minutes and 14 seconds.
Please continue.
There's another outgoing call to the 732, which is again the Neptune Non-Emergency Line. That call took place on April 1st, 2021 at 9:11:43 p.m. That call lasts for 12 minutes and 35 seconds.
Please continue.
The next outgoing call is to the number 609, which is identified to belong to the Barnegat Police Department. That call was was sent on April 1st, 2021 at 9:33:01 p.m. and lasted for 1 minute and 44 seconds.
Please go on.
The next outgoing call was to the number 0, which was previously identified as Jersey Shore University Medical Center in Neptune. That call took place on April 1st, 2021 at 9:56:34 p.m. and lasted for 7 minutes and 12 seconds.
Please move on.
The next number was the 201, which belonged to Mark from DC PMP, which took place on April 1st, 2021 at 10:06:27 p.m. and lasted for 1 minute and 18 seconds.
Please continue.
Next outgoing call was April 1st at 10:51:10 p.m. I believe that number was associated with the Stafford Police Department, and that call lasts for 6 minutes and 8 seconds.
Please continue.
Next outgoing call was the number. That call took place on April 2nd, 2021 at 8:34:02 a.m. and was not answered.
Please continue.
Next outgoing call was identified to be the Ocean County Superior Court. That was on April 2nd, 2021 at 9:06:04 a.m.
Please continue.
The next this is associated with Hackensack Meridian medical records, and that was on April 2nd, 2021 at 9:55:04 a.m. and lasted for 1 minute and 39 seconds.
Please continue.
The next number, this is identified to be associated with the Jersey Shore medical records. This call took place on April 2nd, 2021 at 10:00:54 a.m. and lasted for 25 seconds. Excuse me, 1 minute and 19 seconds.
Please continue.
Next outgoing call, that was identified as the local DC P&P affiliate for Ocean County in Toms River. The call took place on April 2nd, 2021 at 10:00:54 a.m. and lasted for 25 seconds. I think, did I read the 10:00:54 twice? The previous call log for the My Chart was 9:56:55 a.m., if I misspoke with that.
Okay. And just to stop you there, when you say, 9:56:04?
The 9:56:55 was for the Monmouth, Jersey Shore My Records, and then the DC was 10:00.
When you give the 10, are you referring to the hour?
Yes,
And then the next two are the minutes?
that's correct.
And then are the next two the seconds?
Yes.
Okay.
Yes.
Okay.
It goes hours, minutes, seconds.
Okay, I was just checking.
Sure.
Could you please continue?
The next number was called. That number is identified to be with the DC and P&P hotline. The call took place on April 2nd, 2021 at 10:02:42 a.m. and that call lasted for 12 minutes and 38 seconds.
Please continue.
Next call was the contact mom in Mr. Gregor's device. That call took place on April 2nd, 2021 at 3:10:05 p.m. and lasted for 13 minutes and 10 seconds.
Please continue.
The next call was an outgoing call to 2021 at 3:25:11 p.m. and the call was not answered.
Please continue.
The next call was an incoming call from the number below. That call came in on April 2nd, 2021 at 3:25:40 p.m. and lasted for 1 minute and 8 seconds.
Please continue.
The next call was an outgoing call to the phone number. Was identified with a Marcy Brogna, who was an associate of Mr. Gregor. The call took place on April 2nd, 2021 at 4:36 p.m. and was not answered.
How were you able to identify that that was Ms. Brogna?
Sure. So within his phone, there was a Tinder conversation with a contact named Marcy. Mr. Gregor had matched with her on the dating app in January of 2021. Talked for a couple days. Mr. Gregor reinitiated contact with her on March 17th of 2021, where again they spoke for a few more days. And at the end of that conversation, she provided that phone number, and then he then proceeded to text that phone number. And then I believe the case officer looked up the phone number identified to belong to a Marcy Brogna.
Could you please move on?
Sure. The next call is another outgoing call to the 267 Brogna, which took place at 4:42:45 p.m. and that was not answered.
Please continue.
The next call was an incoming call from Brianna and April 1 at 5:00:08 p.m. and that was a missed call.
Please continue.
The next call was a missed call from Brianna Micciolo on April 2nd at 5:00:44 p.m.
Please continue.
The next call was another incoming call from Miss Micciolo at 5:04:08 p.m. and was also labeled as missed. The next call was from 609 Cerulli of the Barnegat Police Department. The call came in on April 2nd at 5:24:47 p.m. And this call was rejected.
When you say rejected, what do you mean by that?
You hit the side button on the phone to send it straight to voicemail.
Please continue.
And the last entry on here is another number from 2021 at 5:25:27 p.m. And that was a missed call from Sergeant Cerulli.
And just to be clear, when you say next, you mean next on the exhibit
That's correct.
S123 excerpts?
I do.
Okay. Your Honor, would you like me to move on to the next section of the witness's testimony now? I'm prepared to do so, or do you want me to save it? I'll defer to the court.
You mean in terms of the lunch break?
Yes.
Yeah, I'm fine with that.
Okay.
All right, ladies and gentlemen, why don't we do that? The testimony obviously is going to be continuing for a while, so you take your lunch break. Again, report back to jury assembly. Don't discuss the case amongst yourselves or with anyone else. Don't do any research or look anything up. If anyone talks to you, please bring it to our attention right away. Don't tell your fellow jurors. I would say 1:30 at jury assembly. Thanks so much.
So I know who's Yes.
Thank you. All right, jury's out of the courtroom at 12:19. Anyone from counsel outside the presence of the jury? You can see it, folks.
No, Judge, thank you.
All right, we had a discussion at Sidebar regarding anticipated testimony about deleted text messages, and courts provided a proposed charge to the attorneys, and Ms. Farafi is going to address that issue. You want to do that after the lunch break, or do you want any more you'd like to say now that we didn't say at Sidebar?
Nothing additional right now.
All right. Nothing else, then I'll see everybody at 1:30.
Thank you, Your Honor.
Judge.
Yep.
double check, make sure all cell phone trees are off around 5 degrees. Received. They're on the way, Your Honor.
Thank you.
How's the meeting doing today? How's the media doing? Good.
The jurors are in the building. All rise. You want them to go right in, Your Honor, if they want?
So, yeah, if you need a few moments in the jury room, you can do that, otherwise we can come right back out. But if you do need a few moments, just tell us, it's fine.
If you want to close it, go ahead. If not.
Have a seat, jury room doors closed.
Yes. Michael?
Sergeant Cole? All rise.
1:44 p.m. right, thank you. Please be seated, everyone. Ladies and gentlemen, we're continuing with the testimony of Sergeant Cole. Sergeant, you're still under oath from this morning. Ms. Strong.
Thank you, Your Honor. Sergeant Coles, in addition to the calls that you testified about, did you review certain emails from the defendant's phone?
I did.
And that's the iPhone 11?
That's correct.
I'm showing you what's been marked as S121 for identification. Could you please take a look at that?
Yes.
Could you briefly describe for the jury if you recognize S121 and what it is?
S121 is a PDF report of 2 emails that were exported from Mr. Gregor's iPhone.
How do you know that?
I've seen these emails on the phone before. Yes, they're from his iPhone.
And is that an accurate report of the information that you have reviewed on the defendant's cell phone extraction in the past?
That's correct.
Okay. And how many emails are depicted on S121?
2.
Could you tell me the date and time of the first email?
Sure. The first email is on April 1st, 2021 at 4:47 p.m. That's from Elizabeth Dreisbach at njcourts.
And what about the second email?
The second email is on April 2nd, 2021 at 9:13 a.m. From Jed's Do Not Reply.
121 into evidence and have the witness describe it for the jury.
No objection.
S121 in evidence. JEDS is the Judiciary Electronic Document System. I don't expect you guys to know all these acronyms, so that's what he's referring to.
So starting with the email on April 1st, 2021, what can you tell me from your extraction report there about that email?
Sure. I can see this email was sent to both Mr. Gregor and Ms. Micciolo. The title was Micciolo FD-12-1384-20 JOTSC, which was the FD would stand for Family Division of Superior Court.
Okay, and do you know if that email was read or not?
The email was read.
Okay. Do you know if there was an attachment to the email?
There was.
And do you know what the email was in regard to?
Filing within family court.
Okay. And on April 1st, 2021, it was an email received by the defendant and Ms. Micciolo?
That's correct.
Okay. And that would have been, could you please detail what is described on S121 about the email?
Sure. The preview in the analyzer gives you a snippet of what the body of the email stated. In this case, it says, "Hello. Please see attached the court's order to show cause in the above matter. Please confirm receipt of this email and the attached order. Have a good weekend. Elizabeth Dreisbach, Law Clerk to the Honorable Patrick Bradshaw, JSC, Superior Court of New Jersey, Middlesex, Vinciage, 56 Patterson Street, New Brunswick, New Jersey, 08903, phone number 732-645-4300, extension 88263, from Elizabeth Dreisbach, elizabeth.dreisbach at njcourts.gov, sent Thursday, April 1st, 2021 at 4:21 p.m.
Now, with regard to the other email, could you describe that listed on S121?
Sure. Again, the snippet states, Superior Court of New Jersey, Ocean County. The following was filed by Christopher Gregor on April 2nd, 2021 at 9:13 a.m. Case caption, not available case number, not available docket text, complaint with order to show cause, emergent, submitted by Christopher Gregor, JEDS EF-641207. Transaction ID not available. JEDS EF ID EF-641207. Documents filed. Document type, document description, file name, FD complaint 11523 underscore 0 OTSC underscore EMERG underscore APP underscore OS C under -3.pdf.
Thank you. Can I just? And I don't recall if I asked you this. You told me with regard to the email from April 1st, 2021, when it was sent. Did you tell me when it was read?
I don't believe I did.
Okay. I'm showing you the exhibit again. If you need it, S121. Is there a subsequent time listed there?
The status was read.
And you had testified about a time, I think it was 4/21. Is there a subsequent time listed with regard to that email?
The sent was at 4:21 from Miss Strasbeck. And received on device at 4:43.
What's that?
And receipt. Again, the email was sent at April 1st at 4:21 p.m.
And you said the status was read.
That's correct.
Now, were you able to isolate any text messages on Ms. Micciolo's Samsung Galaxy cell phone?
I was.
I'm showing you what's been marked as S5 or in evidence, S7 in evidence, S8 in evidence, S9 in evidence, and S11 in evidence. Do you recognize those documents?
I do.
Could you tell us what they are?
They are excerpts of the SMS conversation or text message conversation between Mr. Gregor and Miss Micciolo from Miss Micciolo's Samsung phone.
Okay. And have you seen all of those exhibits in the past?
I have.
And do they accurately depict the text messages that you extracted from Ms. Micciolo's cell phone when you performed the extraction and reviewed the analysis?
That's correct.
I'm also showing you what has been marked previously for identification, I believe, as S10. Do you recognize S10?
I do.
Could you tell me what S10 is?
S10 is a text message or two text message between Mr. Gregor and Miss Micciolo on April 2nd, 2021 at approximately 9:03:10 a.m.
Have you seen that before?
I have.
Is that an accurate representation of text messages retrieved from Ms. Micciolo's phone on when you performed your analysis?
They are.
Your Honor, permission to admit S10 into evidence and have the witness read the defendant's text message.
No objection.
S10 in evidence.
Just the defendant's message? Or both?
If you could read the defendant's text message, but both are on the exhibit.
I see. It's an incoming message from Mr. Gregor to Miss Micciolo's phone on April 2nd, 2021 at 9:03:30 a.m. The message body states, "I am home. Let Corey walk into the house."
Thank you. Now, in addition to messages you isolated in Ms. Micciolo's cell phone, were you able to isolate certain messages in the defendant's iPhone 11?
I was.
And were those from different time periods throughout April 1st and April 2nd, 2021.
They were.
Your Honor, can I place myself on the witness bench? Showing you what's been marked as S-136, S-137, S-138, S-139, and S-140. Could you tell me if you recognize those exhibits?
I do.
And generally, could you tell me what they are?
I can.
What are they?
So S-136 is going to be a text message between Mark from DCP&P and Mr. Gregor's iPhone. This is an outgoing text to Mark at April 1st, 2021 at 5:17:49 p.m. The body of the message states...
I'm just going to stop you there for 1 second. Are all of these text messages in the exhibits that I showed you?
They are.
Okay. Where are they from?
They're from the SMS database on Mr. Gregor's iPhone.
Okay. And do they appear in the same condition as when you reviewed those text messages in the extraction?
They do.
All right. Your Honor, permission to move those into evidence and have the witness describe them.
No objection.
That's 136, 137, 138, 139, and 140 in evidence.
And Your Honor, I don't think that it applies to this bunch, but consistent with Your Honor's ruling and counsel's consent, the witness, I would ask to read both ends of the text message, if appropriate.
Yes.
So, ladies and gentlemen, the statements that are being made to the defendant from another party are hearsay, but as I indicated to you previously, it's often difficult to judge the defendant's response if you don't know what the other party's saying. So I'm permitting those to be read to you. You can't consider those for the truth of the matter. You can only consider those in the context of how the defendant is responding or interacting with the individual from DCP. Thank you.
With regard to S-136, could you please describe to me exactly what that is now?
Sure. Again, that was an outgoing text to Mark from DCP&P. Message was sent on April 1st, 5:17:49 p.m. The body of the message states, "Hey, I can't get off work for tomorrow. I just asked my manager so I can go next week. Just let me know the number to call to schedule."
Could you please go on to the next? Is that S-137?
S-137. This is an outgoing text message to the 267-981-3533 number identified to be associated with Marcy Bragna. The message is the text message was sent on April 1st, 7:48:54 p.m. The body states, "She has him at the hospital getting blood work, ... Not going to be back for a while."
And that's also sent from the defendant's phone?
Correct. That was a sent message to Marcy Bragna.
And S-138, please.
Sure. S-138 is going to be another outgoing message to Marcy Bragna on April 1st, 9:28:25 p.m. The message of the body states, "At police station now."
And that's from the defendant's phone?
That was from the defendant's phone.
S-139.
S-139 is another outgoing text message. This text message was sent to the number 516-617-3053, associated with the contact identified as Laura. This message was sent out on April 1st, 2021 at 9:35:27 p.m. The message of the body states, "2 hours late, she's not responding."
S-140, please.
Sure. S140 is an outgoing text message to the contact identified as Amy, associated with the number 732. This message was sent on April 1st, 2021 at 10:17:20 p.m. The message body states, "Hey, so I'm going to take off work tomorrow because Corey's mom decided not to bring back from visitation, and I'm going to have to go to court tomorrow morning. Since Natalie isn't working, and who do I reach out to?"
Thank you. Now, did you review additional text messages from the defendant's phone from the morning of April 2nd, 2021?
I did.
I'm showing you what's been marked for identification as S141. (142), 143, 144, 145, 146. Could you take a look at those for me, please?
Okay.
Do you recognize them?
I do.
Okay. Generally speaking, what are those exhibits?
They are text messages from Mr. Gregor's iPhone.
And are they all from the morning of April 2nd, 2021?
They are.
And are they all representative of separate conversations or text messages?
They are.
And do all of those text messages and those exhibits accurately represent what you extracted from the defendant's iPhone 11?
Yes, they are complete copies of the messages that were sent or received.
Your Honor, the state's offering those exhibits into evidence, and I'd ask if the witness would be permitted to read them out loud to the jury.
No objection.
That's 141, 142, 143, 144, 145, and 146.
Could you please describe S141 for the jury?
Sure. S141 is an outgoing text message to the 267 Brogna. Message was sent on April 2nd, 2021 at 6:48:19 a.m. The body of the message states, "She has yet to bring my son home."
S142, please.
S142 is another outgoing message to the Marcy Brogna number sent on April 2nd, 2021 at 8:36:08 a.m. The message of the body states, "She just dropped him off."
S143, please.
S143 consists of two text messages from the number The first one is received message to Mr. Gregor's device saying, "Yeah, that's pretty bad, period. Is he all right, question mark." That was sent on April 2nd, 2021 at 8:57:24 a.m. Mr. Gregor replied to that conversation. And I'm sorry, when I read this before, I read the sent number. That's Mr. Gregor's phone number. This text was from Marcy Brogna. And he replied to Marcy Brogna, yeah, on April 2nd, 2021 at 9:05:42 a.m.
Please move on to S144.
S144 is an outgoing text message to Mark DCP&P. The message was sent on April 2nd, 2021 at 9:49:20 a.m. The body of the message states, "Hey, I would appreciate a call as soon as possible this morning considering the events of last night."
S145, please.
Sure. S145 is an outgoing text message to the contact identified as Amy with the phone number 732. It was sent on April 2nd, 2021 at 9:53:25 a.m. The body of the message states, "He's home, but I still apply for an emergent application to remove any visitation moving forward."
And is there more to that conversation?
There is.
Overall, it's just directed at Mr. Rizzo.
Sure. A reply from that text message states, good, it's from Amy at April 2nd, 2021 at 9:54:06 a.m. Body of the message states, good, did she say why she kept him? Mr. Gregor replied to Amy on April 2nd, 9:54:16 a.m. with the word nope. Amy then replied on April 2nd, 2021 at 9:54:32 a.m. with the question, he's okay though, right? And Mr. Gregor replied at 9:55:26 a.m. with the word yeah, yeah spelled Y-E-A-H-H-H with 3 H's.
And S146, please.
This is an outgoing text message to Marcy Brogna, the 267 2021 at 11:53:16 a.m. The body of the message states, well, since I took off from work and my son is sleeping, I'm just hanging out. How about you?
Thank you. In addition to those messages, did you review messages on the defendant's phone from the afternoon into the evening of April 2nd, 2021?
I did.
I'm showing you what's been marked for identification as S147, S148, S149, S150, S151, S152A, S152B, I just want to correct the marking if you could give me a second. Could I have a moment? Just to correct an exhibit number. Thank you. I don't know which number I left off at.
152 A and B.
Thank you, Judge. $153, $154, $155, 157, 158, and 159.
Sure.
Could you take a look at those and please tell me if you recognize them?
I do.
Generally, what are all of those exhibits?
They are text messages from Mr. Gregor's iPhone from the afternoon of April 2nd.
Okay. And are they all separate text messages or conversations, each of those exhibits?
They're all separate conversations. It appears they're all sent messages.
And did you review them prior to coming to court today?
I did.
And do they all accurately depict conversations that you observed in the defendant's extraction from his iPhone 11?
Yeah, the text messages are consistent with what the text messages were identified as.
Okay. Could you please go to S147?
Sure.
Please describe for the jury what is on S147.
S147 is an outgoing text message to the Marcy Brogna number on April 2nd, 2021 at 12:00:55 p.m. The body of the message states, "Nice. I might take a nap so I don't fall asleep at 10 p.m. on you, LOL."
Could you please move to the next one?
Sure.
S140.
Did you move those in evidence?
Judge, I'm sorry. I apologize. Permission to move those exhibits and have them read to the jury. Yes.
So the exhibits of what, 146 through 159, excluding 156, I think you did mention?
I didn't mention yet 155 and 156, and we already covered in the last group. We left off at 146.
Right, I'm aware of that.
So it's 147 through
Through
the rest.
159, excluding 155 and 156?
Yes, Judge, thank you.
Any objection?
No. Could you please, I'm sorry, Judge.
S147 through S154 in evidence, S157 through 59 in evidence.
Could you please move on to the next one?
Sure. S148, this is an outgoing text message to Marcy Brogna. The message was sent on April 2nd, 2021 at 12:14:57 p.m. The body of the message states, "Do you desire a traditional pizza, Domino's, or Pizza Hut?"
Could you move on to S149, please?
Sure. S149 is an outgoing text message to Marcy Brogna on April 2nd, 2021 at 12:19:48 p.m. The body of the message states, "I am actually really excited to see you."
And S150, please.
S150 is an outgoing text message to Marcy Brogna sent on April 2nd, 2021 at 1:01:52 p.m. The body of the message states, "Well, just let me know when is the earliest you could come here."
And what about S151?
Sure. S151 are two text messages sent to Marcy Brogna. The first message was sent on April 2nd at 1:46:32 p.m. The body of the message states, "I'll be able to set it up. I've done it before. I'm just super excited to cuddle after destroying you." The second message states to Marcy Brogna at 1:46:35 p.m. in party.
Please move on to the next exhibit and describe S152A.
Sure. S152A is two text messages sent to the Marcy Brogna number. The first is an attachment of an image, and that was sent on April 2nd, 2021 at 2:06 p.m. And the second is a message stating, "Don't think I'm moving soon."
And I believe in that group at the bottom, there's a 152B. Okay. Judge, permission to show the photograph to the jury. Ms. Lento, if you could, the PowerPoint should be open already. You just need to advance to the next slide.
Sure.
Could you please tell the jury what S152B is?
It's a picture that was taken from Mr. Gregor's cell phone depicting him on the couch with Corey, who appears to be sleeping.
Is that the photograph that was sent to Ms. Brogna?
It was.
Okay, and what time was that photograph sent?
That photograph was sent on April 2nd, 2021 at 2:06 p.m.
Thank you. Could you please move on to S153?
S153 is an outgoing text message to Marcy Brogna on April 2nd, 2021 at 3:22:14 p.m. The body of the message states, "I'm so excited, haha," and so has 3 O's.
And S154.
S154 is an outgoing text message to Marcy Brogna, or 2 outgoing text messages to Marcy Brogna. The first one states, on April 2nd, 2021 at 4:44:42 p.m. Hey, something is going on with my son and I had to bring him to the hospital. The second message at the same time states, I'll LYK when I know what's happening. And LYK would be an acronym for let you know.
Could you please move on to
157?
S157?
Sure. S157 is an outgoing text to Marcy Brogna on April 2nd, 2021 at 2:13:59 p.m. The body of the message states, want to talk on the phone?
And could you please go on to S158?
Sure. S158 consists of 2 messages sent to Ms. Brogna. The first one was sent on April 2nd, 2021 at 12:23:13 p.m. The picture consists of a screenshot of the Pizza Hut menu. The second text message was sent on April 2nd, 2021 at 12:23:39 p.m. The body of the message states, hand tossed, thin crust, stuffed crust, or deep dish.
Could you please move on? S159.
Sure. S159 is another outgoing text message to Marcy Brogna. The message was sent on April 2nd, 2021 at 12:51:47 p.m. The body of the message states, you play chess, with 2 question marks.
And at the end of the text messages that I can take all of them back, that you just reviewed, were they out of chronological order?
They were out of order.
But are the times that you indicated for all of those text messages accurate?
They are.
And those are excerpts from the text messages contained in the defendant's phone?
That's correct. It's not the entire conversation between both parties.
And I'm showing you what's been marked for identification as S155 and S166. Could you take a look at those for me and tell me if you recognize them?
I can.
Could you briefly tell me how you recognize those?
They are sent text messages from Mr. Gregor's iPhone.
And have you looked at them before?
I have.
And are they accurate depictions of what you observed in the defendant's cell phone extraction?
They are.
Your Honor, permission to move S155 and 156 into evidence and have the witness read them to the jury.
No objection.
That's 155 and 166 in evidence.
56? Sure.
156?
156, I think I misspoke, Your Honor. 155 and 156.
No, you said 166 twice, I thought. So it's 155 and 156?
Correct.
The first text message is an outgoing text message to the contact Laura with the number 151. The message was sent on April 4th, 2021 at 9:38:05 a.m. The body of the message states, on my way, with an exclamation mark at the end.
And that was S155?
That was S155.
Okay. Could you please describe S156?
Sure. S156 is another outgoing text message to the contact Laura we just mentioned. This message was sent on April 4th, 2021 at 11:17:14 a.m. The body of the message states, I'm here. Here is spelled H-E-R-E-E-E.
Thank you.
All right, so to correct the numbers, 156 is in evidence, 166 has not been used yet.
Correct, Your Honor.
Thank you.
Yeah, if you can just.
So when you reviewed the text messages in the defendant's iPhone 11, do they go back prior to April of 2021?
They do.
Do they go back to the beginning of the year?
They go back well beyond the beginning of the year.
What's that?
They go well beyond the beginning of the year. Well before, I guess is a better word.
And did you look through the defendant's contacts?
I did.
Did you see a contact labeled mom?
I did.
Okay. What is the phone number associated with mom?
Sure.
Can we just do the last 4 digits, maybe?
Yes,
Is
Judge.
that acceptable? Both sides?
Yes, Judge.
Yes, Judge.
Thank you.
8296.
Are there any text messages with mom in the defendant's phone?
Not before April 1st,
Of what year?
2021.
Okay. Which date is that?
I believe the messages were on either April 3rd or April 4th of 2021.
There's nothing prior to that.
There's not.
Okay. And is there a contact named Dad in the defendant's phone?
There is.
And could you tell us the last 4 digits of that phone number, please?
Off of this, I can't recall the 4 numbers, but I cannot recall Dad's phone number.
Okay. Do you remember seeing the name Dad in the contacts?
I did.
Okay. And were there any text messages with the contact Dad in the defendant's phone?
There were.
What's that?
There were.
When's the first one?
And I believe it was on April 3rd of 2021.
So there were none prior to that?
Let's phrase it like this. There were no messages prior as an individual conversation. There were some group chats that took place well before March of 2021.
Now, after reviewing the text log, were you able to review searches performed on the defendant's iPhone 11?
I was.
Okay. And were you able to isolate certain searches?
I was.
I'm showing you what's been marked for identification as S122. Could you take a look at S122?
Yes,
Do you recognize S122?
I do.
What is that?
They're identified as either searched items or web history from Mr. Gregor's iPhone's Safari web browser.
And is that all of the search history from the defendant's iPhone 11 or excerpts from the defendant's search history?
It's an excerpt of the searches from the date and time,
Okay.
or the time range.
How did those items get into S122 like that?
Like this. In this case, we did what's called a tagging within the Celebrate Reader software. We tagged the individual entries. We went to the tags portion and then exported out all the tags in reference to his search items and web history.
And are the items that are depicted on S122 accurate representations of what you reviewed as part of the defendant's search history in his iPhone 11?
They are.
Your Honor, permission to move S122 into evidence and have the witness read from it to the jury. No objection.
S122 evidence.
Now, is S122 in chronological order or reverse chronological order?
Reverse chronological. The most recent is the highest on the entries.
Could you please start from the earliest date in S122 and describe for the jury the information that's there?
Sure. So the first hit in the Safari web browser on this was a search conducted on March 25th, 2021 at 9:36:31 p.m. The body of the search states, "Will red marks turn into bruises?"
And could you please move on to the next one?
Sure. Next search is on April 1st, 2021 at 8:43:36 p.m. The search was Neptune Non-Emergency Police.
The next one.
Next search is on April 1st, 2021 at 8:49:05 p.m. The search was Jersey Shore Medical Center.
Please move on to the next one.
The next one is a web history on April 2nd, 2021 at 3:08:37 p.m. The search was lost consciousness, sleepy and nauseous - Google search.
Please move on to the next one.
Next entry is April 2nd, 2021 at 6:10:22 p.m. The search was, can your phone be tracked in airplane mode?
The next one.
The next search was for April 2nd, 2021 at 6:10:35 p.m. for, can my car be tracked?
The next one.
The next search is on April 3rd, 2021 at 3:14:24 p.m. The search is, what causes a rise in blood sugar in white blood cells?
The next one.
Gotta rip your staple. Can't see the time. Next search was for April 3rd, 2021 at 3:55:40 p.m. The search is, could internal bleeding raise your blood sugar levels?
Please move on to the next one.
The next search is on April 3rd, 2021 at 3:56:55 p.m. The search is, how does gastrointestinal bleeding happen?
Could you please move on to the next one?
The next search is on April 3rd, 2021 at 4:28:21 p.m. The search is, how does gastrointestinal bleeding, how pong to die? It's P-O-N-G, to die.
Could you please move on to the next one?
Sure. The next search is April 3rd, 2021 at 6:55:22 p.m. The search is, can a GI bleed be slow?
Can you please move on to the next one?
Next search is going to be on April 4th, 2021. The value is McGee Tyson Airport, parentheses, TYS, and parentheses, comma, 2055 Alcoa Highway, Alcoa, Tennessee, 37701. Position is parentheses, 35.081033, comma, dash, 83.993889.
Is there a next one?
There is.
Could you please tell us what it is?
Next search was on April 4th, 2021 at 9:58:03 a.m. The search was, there was a murder determined from an autopsy. How long to file charges?
Is there another one?
The last one is on April 4th, 2021 at 10:21:16 a.m. The search was, how long after an autopsy to file charges get filed?
Thank you. Now, in addition to the text, calls, emails, searches, the things you saw on Ms. Micciolo's phone, were you asked to analyze other data and render any opinions?
I was.
Okay. I'd like to go through those with you now. How many tasks were asked of you?
Sure, they proposed 7 questions to me they want to know more details about.
Okay, when you say they.
The state and the case officer.
And did you analyze all 7 of those tasks and render opinions?
I did.
Could you please describe to me what the first task was and what you did?
Sure. The first thing they proposed to me was to identify if conversations between Christopher Gregor and Brianna Micciolo were deleted from Christopher Gregor's iPhone. If messages were deleted, please identify when they were deleted.
What did you do with regard to that?
So essentially, I opened up Ms. Micciolo's phone extraction, and I opened up Mr. Gregor's phone extraction. On Mr. Gregor's phone extraction, there were 0 text messages with Ms. Micciolo. On Ms. Micciolo's phone extraction, there were 3,466 text messages saved with a conversation with Mr. Gregor. That was the first indicator that something was deleted from Mr. Gregor's phone. I looked at the message retention settings within Mr. Gregor's iPhone and saw the value for message retention duration on his phone was set to forever, as in messages would not be deleted unless a user did it themselves. In order to kind of really dig in to make sure they were received on this device, I opened up the sms.db. That's going to be the text message database for Mr. Gregor's iPhone. And to give you an idea of what a database is or what it looks like, the best way I can describe it is to compare it to a Microsoft Excel spreadsheet. The Excel spreadsheet is going to have multiple rows and columns. On Excel, you can have different pages, and essentially inside the database, there's going to be different tables. These tables cross-reference with what's known as the primary key, where you can search additional data from different tables by referencing the primary key ID of an entry. Databases will generally run sequentially, as in they'll go 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. If there's gaps in the sequence, it's indicative that content is no longer present on the device. Whether that means it was automated or automatically deleted by the phone itself, or if a user might have gone in and deleted the entry. So in this case, what I did is I opened up just 6 random messages from Miss Gregor's phone that were sent to Mr. Gregor's phone. I compared the native timestamp of when those messages were sent from her phone, and I corresponded that with the text message database on Mr. Gregor's phone. And during that, I identified a sequence gap of approximately 7 messages, which would be consistent with entries that would have been there from Ms. Micciolo's phone. I repeated that again, picking a random message, searching Mr. Gregor's iPhone's text message database, and identified that the time of a sent message from Ms. Micciolo's phone was consistent with a missing entry from Mr. Gregor's phone. Last thing I did is I checked to make sure that Ms. Gregor's contact was not blocked at the time when I received the phone, and her phone contact was not blocked.
Sorry, can I stop you? Do you mean Ms. Brianna Micciolo?
I do, yes.
Okay.
So Ms. Micciolo's phone number was not blocked by Mr. Gregor's iPhone. So based off this, seeing as there were missing gaps in his text message database, consistent with messages that were sent from her phone, it's my opinion that Mr. Gregor deleted the text message conversations with him and Ms. Micciolo on his phone. I have no way to tell you when those messages were deleted.
And that's the opinion that you rendered with regard to task.
It was.
And were you able to print out all of the text correspondence between Ms. Micciolo and the defendant from Ms. Micciolo's extraction?
I did.
Approximately how many pages was that?
880.
So 880 pages of text messages were gone from the defendant's phone.
That's correct.
What was the next task that you were asked to complete?
So when the case officer was reviewing the phone extraction, they notified there was really no messages sent or received to the device between the afternoon or evening of April 2nd of 2021 until approximately 2 o'clock on April 3rd of 2021. Their primary goal was to identify if the phone was either shut off or what the status of the phone was during that time frame.
And what did you do with regard to that second request?
Sure. So the first place I really went to was, it's called the knowledgec.db database. KnowledgeC at the time was mostly like an event logging feature of an iPhone tracking different activities going on in that device. I looked at the device being unlocked, and I could see that his device was unlocked multiple times between the hours of approximately 7 p.m. until 7 p.m. on April 2nd until 1 p.m. on April 3rd. In addition to looking at the KnowledgeC logs for device being unlocked and locked, I went to what's known as the routine-d or cache.sqlite. This database is going to be where your phone is storing what's known as significant location data. Significant location data is going to be data that an iPhone is going to use to help with predictive traffic routing or to help set memories in your photographs. During this time frame, from the evening of April 2nd until the afternoon of April 3rd, there are approximately 60,000 GPS fixes. GPS fix essentially being a ping for where that phone was. These logs will not generate if the phone is powered off. And I can identify that the phone could be tracked all the way from New Jersey down to the southwestern portion of Arkansas. And the last thing I did to review this was I wanted to check the actual airplane mode status. Within the knowledge database, I specifically searched for the airplane mode flag, and I could see the phone was placed in and taken out of airplane mode several times during that evening. The most notable being the phone was placed in airplane mode on April 2nd at 6:38 p.m., and it was not taken out of airplane mode until 2:13 p.m. on April 3rd.
Did you render any expert opinion with regard to that second task that you were asked to perform?
I did.
What is that?
So based off the device being unlocked, these GPS fixes being generated, which will not happen when the device is powered off, and the fact that the device was in airplane mode, it means the device was powered on and being utilized. However, no messages were sent or received due to the device being in airplane mode.
What was the third task that you were asked to perform?
Sure. So there was a picture we saw before of Christopher Gregor and Corey Micciolo sitting on the sofa with Corey appeared to be asleep. They want to know if that picture was taken at the date and time the message was sent.
And are you referring to S152B?
I am.
Say that.
I am.
Okay. Could you please tell me what you did with regard to that task?
Sure. So I found the original text message containing the photograph and then identified the source file path of the photograph itself. It's kind of hard to read this file path. The file path is going to be private/var//7DA5-42907955243 underscore 6F47F270-4FAD-8840-060DFF770F39.HEIC.
What is all that?
Exactly. So that is where the phone was saved on the photograph was saved on the phone itself. Based off this, HEIC is going to stand for High Efficiency Image Codec. That's going to be the native format an iPhone is going to take a picture in. The fact that this picture was in this directory would be indicative that the picture wasn't taken through the camera application. Rather, he had the text message open and took the picture he took the picture through the text message application. So essentially what I did is I went into the photos.sqlite database, which similar to the another database where we cross-referenced data and identified the Z creator bundle ID of the photograph was again com.apple.camera.camera messages app, and I could identify that this picture was taken on April 2nd, 2021 at 2:05:52 p.m.
So with regard to the third task, your opinion would be that the picture was taken on that date and at that time?
That's correct.
Could you please move on to the fourth task?
Sure. There was a video identified on Brianna Micciolo's phone on April 2nd, 2021 at 9:02:50 a.m. Case officers want to know if this video was taken on that device and if there's any location data to identify where that video was taken.
Are you referring to S15A?
I am.
Please continue.
So I went into the phone's gallery, identified the specific video. It was located at the directory, data/media/0/DCIM/camera/2021-0402_090215.mp4. That is consistent with the native camera app on a Samsung Galaxy phone utilizing an Android operating system. I then went into the gphotos0.db. I just mentioned the photos.sqlite database from an iPhone. The gphoto0 would be the equivalent on an Android phone. I identified that the capture timestamp of that picture was taken at 9:02:50 a.m. This would be an instance where the time is actually in Eastern Time. And there's also a UTC timestamp with that, which is exactly 4 hours faster. Throughout the database, there's also an entry for location data. It was a null value, as in there was nothing there. So this phone had this video had no location data associated with it.
So with regard to the fourth task, did you render any expert opinion?
I did. The video was taken at the date and time it was reported to be at 9:02:50 a.m. And there is no GPS location data associated with that video.
What about the fifth task? Were you asked to perform the next one?
I was. So the next task involved the Grubhub application to identify if there's any transactions on Grubhub during the afternoon of April 2nd of 2021 between the hours of 1 p.m. and 3 p.m.
Could you tell me what, if anything, you did to look into that?
Sure.
task?
So the first thing I did is I started digging into the Grubhub system, all the Grubhub files within the file system of the phone, trying to search for any databases that actually contain transactions. I could not locate any. I believe that would be indicative that the searches would be stored on Grubhub servers on a cloud, not on the device itself. However, there was activity to indicate that Grubhub was utilized on this device during that time. So what we started to do is look at the application usage logs on that phone, and I can see that the Grubhub application was utilized for approximately 12 minutes and 27 seconds between 1 p.m. and 2 p.m., and that Grubhub was utilized for approximately 2 minutes and 39 seconds between 2 p.m. and 3 p.m. In addition to the application usage logs, there were also text message artifacts that would be associated with Grubhub. For instance, there was a received message on April 2nd, 2021 at 1:54:04 p.m. From the short SMS number, or short code SMS 303 states, McDonald's is preparing your order to be delivered between 2:20 p.m. and 2:30 p.m. Track your food online or with the Grubhub app, grubhub.app.link/SMS. There's another message after that says your order is on the way and will arrive between 2:20 p.m. and 2:30 p.m. That was sent on, or that was received on April 2nd, 2021 at 2:14:34 p.m. And the third message was your Grubhub driver will arrive with your order soon. To keep everyone safe, please wear a mask. This was received on April 2nd, 2021 at 2:16:34 p.m.
Did you render an opinion with regard to that fifth task?
I did. Based off the Grubhub app being utilized and the device receiving text messages from Grubhub in regards to an order being placed, it's my opinion that the device was utilized to place an order through Grubhub, specifically to McDonald's as referenced in the text message.
And what was the time frame? Were you able to determine a time frame?
Of when it was utilized?
Yes.
Yeah, it was going to be primarily utilized between the hours of 1 p.m. and 2 p.m. and the hours of 2 p.m. and 3 p.m. for approximately 2 minutes. So overall, the app was utilized for roughly 15 minutes between 1 and 3 p.m.
With regard to the sixth task, what were you asked to do?
Sure. Before we reference the text message to Marcy Brogna, let me read the task. Please identify a screenshot of a Pizza Hut menu that was sent from Christopher Gregor's iPhone on April 2nd, 2021 at 12:23 p.m. That was sent to the number 2.
Did you do anything in that regard?
I did. So in this case, I pulled up the text message to Marcy Brogna that depicted the Pizza Hut menu. I identified that the picture was identified as img_4862.png. The img_45, or img_XXX is going to be associated with something saved natively to the device's gallery. The extension PNG is the proprietary form, or not proprietary, is the format that Apple uses when you save a screenshot on your phone. I went into the photos.sqlite database and identified the file name associated with img_4862 and identified that the screenshot was taken on April 2nd of 2021 at 12:23:08 p.m. I then cross-referenced that with the Z additional asset attributes table, identified the Z creator bundle ID was com.apple.springboard, which is associated with the device's home screen, or the screen on the device.
What, if any, opinion did you render in regard to that task?
There's still a couple additional things I did for that. In his web history, there was no web search for Pizza Hut on April 2nd. However, in this case, there was additional database in his Safari browser called the favicons.db. A favicon is going to be the little picture on your web browser associated with that website. For instance, if you go on google.com, you'll see that little G in the corner of your web browser tab. If you go to Facebook, you'll probably see the little F in the corner of your tab. That is what a favicon is. In this case, I referenced Pizza Hut within the favicons database and identified a timestamp that shows Pizza Hut was accessed on this phone on April 2nd, 2021 at 12:22:17 p.m. So based off this, it was indicative to me that the picture was taken on his device on April 2nd of 2021.
At what time?
12:22:17 p.m.
Okay. And what about the seventh and last task that you were asked to perform?
Sure. The last task involved deleted search history that was identified within the Safari web browser. The initial terms that were identified as deleted were Neptune Not Emergency Police, Jersey Shore Medical Center, Lost Consciousness, Sleepy, and Nauseous. So what we wanted to do is go in and verify that these records were deleted and to identify when they were deleted. So in this case, I saw inside the Physical Analyzer software, if an entry is identified as or detected as it might be deleted, there'll be a little X in a column which represents deleted artifacts. So the first thing I did is opened up the actual database associated with the Safari web history and identified the date and times of these entries and identified that there were no entries locally in the Safari database. Before, when I talked about sequence gaps, I've reviewed the raw database and identified that there were sequence gaps present in his Safari database, which would have been consistent where these logs would have originated from, or that time they would have been originated at. So in this case, when you're using Physical Analyzer software, you can click the source file and it'll open up the raw database and show you where it found what it's talking about. So in this case, with the Neptune Non-Emergency Police, I opened up the database and found the raw search still saved in there. So while it's no longer logically available in the database tables, that spreadsheet I was talking about before, the raw text was still available in the database. And most important thing to do is when you have a deleted artifact is to verify and validate the times being reported are accurate. I identified for the Neptune Police, the Jersey Shore Medical Center, Google search, I identified the time offset. In this case, the time isn't stored in plain text that me or you look at on a daily basis. The format that this time is stored as, encoded as, is called double precision floating point format. So it's a string of hexadecimal characters, which then corresponds with a text or a plain text value, or excuse me, let me rephrase that. It converts to a plain text value that we would see. In this case, a timestamp is going to be in MAC absolute time. This is the format that an Apple iPhone is going to save dates and times in. So it's not saving in dates and times like we look at date and times. For this specific entry, the date entry was identified as 639017345.49637496471. This is going to be the number of seconds or milliseconds since January 1st, 2001 UTC, which would be 0000. For us, if we were to look at that time, it would depict December 31st, 2000 at 7 p.m. if we were to look at it in our time zone. So what I did is I converted that and verified that the time value was equal to what it was being reported as. So I could see that the search for Jersey Shore Medical Center was conducted on April 1st, 2021 at 20:49:05 p.m. I repeated that process for the other searches, such as the Neptune Non-Emergency Police. So I can tell that search was conducted on April 1st, 2021 at 20:43:36 p.m. And I repeated the same process for Lost Consciousness, Sleep, and Nauseous, and could tell that search was conducted on April 2nd at 3:08:37 p.m. While these searches were deleted, I don't really have an accurate way to tell you when these were deleted. There's no way that I know of currently to say this was definitively deleted at this date and time.
Would it be true that you have to delete a search after you perform it?
The searches were deleted after they were conducted.
Okay. So with regard to task 7, your opinion would be that the lost consciousness, sleepy, and nauseous was deleted after it was performed?
That's correct.
Is it a good time to take a break?
Your Honor, yes, we could take a break. Thank you.
Unless you're about to be done, you can direct, but well, that's fine. If you're not, you can come back out.
Your Honor, I have no further questions for the witness.
All right. Any objection to the break in?
Not at all, Judge.
All right. So, ladies and gentlemen, we'll take our mid-afternoon break. Please don't discuss the case before the opinions.
All rise.
All right, thank you. Please be seated. Before we take a break ourselves, a couple of issues. Sergeant Dugan went over and had the jurors on either side of juror number 12 give him a little nudge. His eyes appeared to close briefly. He's wearing glasses, so it was tough to tell, but he did appear to startle when they nudged him, so he may have dozed off. Counsel, any position how you want me to address that?
Judge, I don't know how long he was asleep for, so I will defer to you. I know that once your court staff did notice he was asleep, they made progress very quickly to make sure that he wasn't.
Would you like me to interview him, or?
No, I'll defer to you, Judge. If you think he should be interviewed, interview him. But I don't know how long he was asleep for. Do you know how long he was asleep for?
I'm going to defer to Mr. Gallucci and Your Honor. I was asking the witness questions. I did look over at a period of time, especially when my attention was drawn to what was happening. But I'll defer to Your Honor.
I mean,
From your
he
perspective.
anyway, and the testimony is very technical. He's reading these different hash values or...
Yes, the 40 letters and
Right.
numbers towards the end. Yes, that was very long.
All right, well, without a request to interview him, I don't want to make it a habit of always interviewing jurors. For the most part, I find they're all paying attention. Just give me a moment.
Just figure out time.
Addressed previously in case law. So courts are required to take corrective action if someone notices a sleeping juror. See, for instance, State versus Scherzer, SCHERZER, 301, New Jersey, Super 363 at 491, a television case in 1997. Here, court would like to thank Sergeant Dugan for going over and advising the other jurors to give juror number 12 a nudge, which they did. He immediately came to attention. I then watched him closely for the remainder of the testimony until we took a break, and he did not appear to nod off or doze off. So the burden then shifts to counsel for either side to ask the court to take some type of action. Again, if you want me to take any action, I will. But absent that request, if I'm satisfied that you're in paying attention and continues to pay attention, there's no need for any action. See also State versus Mohammed, 226 New Jersey, 71 at pages 87 and 88, a 2016 New Jersey Supreme Court case. So again, while the jury's not here, does anyone have any requests for me to take any action or interview the juror?
Not at this time, Judge, but we'll keep an eye on him and we'll come to habit. Maybe change my mind.
All right, we previously discussed giving an instruction on deleted text messages, and I believe Ms. Ferranti is dealing with this, so I think that needs to be expanded to deleted text messages and deleted search history.
Yes.
In addition, there also is an issue related to, but slightly different than the deletions. It's that the post-offense conduct of internet searches, which occur, according to Sergeant Coles, April 2nd, 3rd, 4th, and so on. For instance, about medical issues, or can my phone be tracked? As I said, that is similar to, but not exactly the same as deleting them. It's still post-offense conduct. It's come out in front of the jury. All this was previously dealt with as part of 104 hearings, and counsel asked me to defer a final ruling on these until such time as the testimony came out in front of the jury. One of the cases I'm guided by is a case called State v. Rochat, R-O-C-H-A-T, 470 New Jersey Super 392. It's an appellate division case from 2022, and that deals with, among other things, post-offense conduct, and indicating that, like deleting messages or search history, that can be relevant to consciousness of guilt, but it probably requires a limiting instruction. I shouldn't say probably. All these things require limiting instructions to identify for the jury the permitted and prohibited purposes of that evidence. So do you want us to try and do a separate limiting instruction on this internet search history post the child's death, or do you want to combine this all in deleted text messages, deleted search history, and search history in general? We just tried to, my law clerk and I were just drafting a limiting instruction on the search history as that was going on. Keep in mind, no one's requested this of me, but I believe that I'm supposed to bring this up since we're talking about other conduct apart from the time of the offense.
Judge, can I have one moment?
Sure.
We would ask for separate charges for those two scenarios, just to make sure there's no confusion amongst the jury in terms of the charges itself.
All right, so in terms of the deletions, though, can we say deleted text messages and internet history in one, and then internet history in the other?
That's fine.
Or deletions from
That's fine.
phone or something? Okay. Absolutely. No objection to witness use of the restroom?
No, not at all.
Thank you.
You have all these.
If I can, I'm going to ask to see S-136 from the people.
Right.
I'm sorry, through 159. I do already have in my possession S-10, I believe also 155 and 156.
Can I see what you have there? I don't know which ones you have already. I'm gonna just hand you. I'm gonna just
Two
hand.
additional limiting instructions for you that we just discussed. Counsel reviewing them, and I'll give it to the jury before the cross-examination.
As long as I
Is that
can
what you
hold
want? Or after the cross?
I should have come.
That's okay.
Before the cross, please.
All right. Can I have that? Your Honor, may I approach and just collect the exhibits so I can have them for reference?
Sure.
Thank you. Don't let him organize. I did that last time.
You're not allowed to organize.
That's my exhibits. Huh?
Yes.
Right. Not right now. Thank you. He kept his, I have his CV, but I know he has his report. Does he need his notes back in his other report?
I don't need those notes.
Okay.
Or maybe let me have the other report too.
Shannon. Sorry. He did say he wanted these. Thank you.
Is that both or notes on the report?
What's that? Notes on report
All right.
right there.
If we need it.
Okay.
Yeah, that's fine. I'm so sorry.
SQ light. SQ. S just capital S, capital Q, LITE. You see SQLite. Yeah. I've gotten slower, but my enunciation is
Limiting instructions. One is entitled Internet Searches. The other one is entitled Deleted Internet History Under Text Messages. Court staff needs a brief recess, so we'll take a break and come back to that. I'll hear from either side any objections or concerns. It's acceptable to mark them as court exhibits, and then I'll advise the jury of those instructions before they hear any additional testimony.
Thank you, Ron.
All rise. Step out.
I have to use these ladies.
Yeah.
And I'm going to
I'm
step
gonna
outside 5 seconds.
Okay. Do you need me? Do you need to check?
Courtroom is open, but the jury is still in the jury room.
I was going to request a conference of people before stepping back on record. The way part of the instructions are phrased, fourth paragraph down when it comes to internet searches, and then the deleted history and text messages, third paragraph down, if you find the defendant's explanation credible, I just have a concern with the way that is postured because we don't know what's going to come out during the cross-examination and what explanation, if any, might be given. So I just don't want to get into an issue where the jury believes they have to hear that or something from the defense.
Judge, I had an issue with that, and I also had an issue under internet searches, the third paragraph down. If we could just use the second part of the sentence on deleted internet history and or messages that says the defense has suggested there are explanations for the deletions on both instead of, I'm sorry, if we could use the defense may provide some explanations for these searches instead of the defense has suggested, because we don't know what they're going to do, and cross-examination isn't necessarily like what it purports to be. And I think, obviously, like in a final charge, these might be different after the defense has finished their case, but not mid-trial.
All right, so starting with internet searches first. Third paragraph. Currently says, quote, the defense may provide some explanation for these internet searches. If you want to say, although not required, comma, the defense may provide some explanation for these. Although he is not required, the defendant may provide, or the defense may provide some explanation for these internet searches. So that'll be changed to, quote, although he is not required to do so, the defense may provide some explanation for these internet searches. Next sentence. If you find the defendant's explanation credible, you should not draw any inference of the defendant's consciousness of guilt from the defendant's internet searches. That language, if you find the defendant's explanation credible, is basically from the model charge on flight or post-defense conduct. Do you want me to modify that somehow?
I do. I just don't have a suggestion of no one will count him off. To make it clear that he has no burden of proof and is not required to offer an explanation.
Well, we can certainly change it to any explanation, but if you find that the internet searches are not helpful to you in this case, or if you find any explanation by the defendant credible, you should not draw any inference.
That would be acceptable.
Judge, can you say that again? I'm sorry.
Let me write it out.
Yeah.
All right, so the revised fourth paragraph on the charge entitled Internet Searches would read, quote, if you find that the Internet searches are not helpful to you in this case, or if you find any explanation by defendant is credible, you should not draw any inference of the defendant's consciousness of guilt from the Internet searches.
Okay, Judge. So you're just adding that one part to the front.
All right, so now, while we're changing that around so we can pass it out to counsel, going to the next one entitled Deleted Internet History and or Text Messages. You want to use that same language about, although not required to do so?
Yes.
This is before. Just go back to something on internet searches. I'm sorry. I don't want Ms. Grimaldi to finish. And then in the first paragraph, it says, you have heard testimony and evidence was admitted that a phone owned by and subscribed to by the defendant was utilized to search the internet using certain internet search terms, and that this occurred after the date set forth in the indictment. It was before and after one of the dates. I just didn't want it to be misleading in any way. There was a search that was testified to on April 25th, the first day in the indictment. So I just wanted to bring that to the court's attention. And the
Searches
subscribe.
on April 25th and April 1st would not be post-offense conduct. They'd be intrinsic to the crimes charged.
Okay.
And would not, in my view, really require limiting instructions then, because it's contemporaneous to the alleged acts. It's the offenses after the child's death, the conduct after the child's death, which would require limiting instructions. So I don't want to start.
Understand, Judge.
The communications and all these things happening between the parties are clearly relevant to what's happening. Ordering McDonald's is relevant to whether or not he's harming the child at that time or whether he's ordering the child food. But that's different than what he's doing the next day when he's allegedly going to another state and or doing his internet searches. So I'd rather keep the instruction confined to after the incident in the indictment, because that's when the instruction's required. Let's work on the deletion instruction. Revision for the part about the deletion. We're going to try and get them printed and handed out to you right away. Can you give me a printed please today?
Yes.
All right. Then we've already 3:20, so.
Yeah.
I'm just asking because I know you have a witness from out of state tomorrow, so we need to juggle things around. Let's talk about it before we recess for today.
Yes, Judge. I was speaking to Mr. Gallucci before about if it was necessary, if counsel wanted to ask Your Honor, if rather than having this witness come back for 5 or 10 minutes, we could finish it today. But I told counsel to ask Your Honor if he thought that that was appropriate.
Let's see how far we get. Position from defense on the instruction entitled searches.
I think both are acceptable, Judge.
Okay, both are acceptable. Madam Clerk, court's exhibit next in order with internet searches first, deleted internet and text second.
What are they marked, please?
Internet searches is C11 in evidence, deleted internet history under text messages is C12 in evidence. So, Amy, we're going to jury back out? Okay. Very good. 3:23 p.m., jury back out.
All rise. Jury out.
Thank you. Please be seated, everyone. Ladies and gentlemen, before we go to the cross-examination, there are a couple of additional instructions that I need to give you. The first is regarding the internet searches that you heard about. You have heard testimony and evidence was admitted that a phone owned by and subscribed to by Christopher Gregor was utilized to search the internet using certain internet search terms, and that this occurred after the date set forth in the indictment. The question of whether the defendant made these searches is another question of fact for your determination. If you find that the defendant, fearing an accusation or arrest would be made against him on the charge involving the indictment, made those internet searches, then you may consider saying in connection with all other evidence in this case as an indication or proof of consciousness of guilt. There has been some testimony in this case from which you may infer the defendant made certain internet searches from his phone. Although he is not required to do so, the defendant may provide an explanation as to his internet searches. If you find that the internet searches are not helpful to you in this case, or if you find any explanation by the defendant is credible, you should not draw any inference of the defendant's consciousness of guilt from these internet searches. If, after consideration of all the evidence, you find the defendant, fearing that an accusation or arrest will be made against him on the charge involved in the indictment, made those internet searches, then you may consider saying in connection with all other evidence in this case as an indication or proof of consciousness of guilt. It is for you, as judges of the facts, to decide whether or not the evidence of the defendant making certain internet searches shows a consciousness of guilt, and the weight to be given to such evidence in light of all other evidence in the case. And there's a second instruction regarding deleted internet history and or deleted text messages. There has been some testimony in the case from which you may infer that the defendant deleted text messages and or internet searches from his phone. The question of whether or not the defendant deleted anything from his phone is another question of fact for your determination. If you find the defendant, fearing an accusation or arrest will be made against him on a charge involved in the indictment, deleted contents from his phone, then you may consider saying in connection with all other evidence in this case as an indication or proof of consciousness of guilt. There has been some testimony in the case from which you may infer that the defendant deleted some items from his phone. Although he is not required to do so, the defendant may provide an explanation for the deletions. If you find that the deletions are not helpful to you in this case, or if you find any explanation by the defendant is credible, you should not draw any inference from the defendant's consciousness of guilt from the defendant's deleted content. If, after consideration of all the evidence, you find the defendant, fearing that an accusation or arrest would be made against him on the charge involved in the indictment, deleted items from his phone, then you may consider saying in connection with all other evidence in the case as an indication of proof of consciousness of guilt. It is for you as judges of the facts to decide whether or not evidence of the defendant's deleting items from his phone shows of consciousness of guilt and the weight to be given to such evidence in light of all other evidence in the case. And again, I would give those instructions to you as part of my final charge in the case as well. Thank you. Ms. Ferranti, cross-examination.
Thank you.
Good afternoon.
Going back to when you looked at the hospital video.
Yes.
Now, you didn't actually go and retrieve that video, correct?
No, I gave them legal authorization. They gave us the video.
You gave who the authorization?
The security staff. We gave legal authorization to the security staff for them to provide us with the video.
The security staff at the hospital?
Yeah, and they sent it to their legal team so they could release the video to us.
And this is Southern Ocean Medical Center, correct?
It was.
I'm sorry. What was your answer? I said it was Southern Ocean Medical Center.
Where
You
we-
answered at the same time.
Sorry.
So I just wanted to make it clear for the record. It's Southern Ocean Medical Center.
That's correct.
Thank you. When you first received hospital video back, you said the files were corrupted?
One of the discs had the actual video on it. The other 8 discs only contained hyperlink files to the videos themselves. Since we don't have access to their network, we can't access those hyperlinks and we're not able to access the video. We contacted the security staff and then they gave us one DVD that contained all the footage on it.
Now, at one point you said there was a time offset of 3 hours for the exterior video. Correct?
That's correct. Approximately 3 hours.
Approximately 3 hours. I think you said actually 3 hours and 3 minutes?
3 minutes.
Now, that's for the exterior video facing the drive when you pull up to the front of the hospital.
That's correct.
Were you aware that there was a video or camera at the opposing side of the front of the hospital where the ambulance enters?
I was.
Did you seek that from the hospital?
We gave them the legal authorization and they gave us what they deemed relevant of the investigation. Or what they decided to give us is what they gave us.
Well, just to be clear, right, the hospital is not investigating what occurred
No.
when it comes to Corey Micciolo.
That's correct.
So when you got back the video and didn't see anything from the ambulance entrance, you didn't follow back up?
We give the video to the case officers. If they wanted more footage, they would request us to pull more footage or request for more footage.
Okay. The case officers that get the video, they are the ones that review the video?
Primarily.
Is it fair to say that after the case officers review the video, they come back to you and give you the highlights?
In some instances, if it's necessary.
Are there instances where you wouldn't get the highlights?
What the case officers do with the video, like, we fulfill their request. They request the video, we give them the video. If I don't know what they, most of the time I don't know what they do with the video. There's no, criminal proceedings that go along with the case. Except we get, we give, and they review. And again, we review the video to an extent that we make sure what we got is accurate in the sense that it covers the proper time frame. Make sure we, got the right data video. Make sure the video plays back. Most of the time when you export video, it might have a proprietary player that the case officers might have issues playing back with. We always make sure that the footage is in a working capacity before providing it to them.
So when you determined there was a 3 hour and 3 minute offset for the exterior video, did you ever advise the hospital of that?
I did not.
Now, you also mentioned you have a certification in Axiom by Magnet?
Yes,
Now, Axiom is an alternative provider to cell phone extractions, correct?
it is.
You chose to use Celebrate.
I did.
Did you validate your findings with Axiom?
Why would I validate with Axiom?
Isn't it protocol to validate your findings from any particular cell phone extraction provider you use with a second provider?
Yeah, so a lot of this case what I did is I validated those results with online tools. Decode is a date and time conversion tool. I can review the actual database and found the database to be consistent.
Now, so you just didn't use a second provider?
I did not use the second software, no. I'm more proficient with the Celebrate software.
I appreciate the clarification. Prior to the cell phone extraction for, let's for example take Mr. Gregor's iPhone 11.
Sure.
What date did you actually perform the extraction?
The extraction, I believe, was conducted on April 8th.
Of 2021?
That's correct.
Prior to April 8th of 2021, when was the last time you had updated Celebrate?
Well, I didn't do the extraction with Celebrate. I did the extraction with Gregor. Gregor automatically updates.
And what about Celebrate? Did you update that?
We usually use one of the most recent versions of Celebrate.
And after April 8th of 2021, when was the next time you updated it?
When was the last time we updated it? I couldn't recall. Usually an update comes out, it ebbs and flows. Sometimes an update might come out every month. Sometimes an update might come out every 2 months. Usually we'll wait a week or two before you update. Sometimes there might be a bug in the software. If there's an issue, people will report that, and then they'll usually release a hotfix, and that issue might be rectified, and we'll move forward and use that version.
Now, have you ever been in a situation where you've used Celebrate to do the extraction, gotten an update, and gotten more information or data from what you were extracting?
So, only in terms that new capabilities would exist to do an additional extraction that wasn't previously available.
Can you explain?
Sure. So, we did the full file system extraction of Miss Micciolo's cell phone. That is the highest tier extraction possible to do for that cell phone. If we were to redo that extraction, we'd actually probably get less data because, again, sometimes system files or internet history might automatically purge after 30 days. So usually the first time you do it, if you can do the highest tier extraction possible, will be your best outcome moving forward.
Now, in terms of Micciolo's cell phone. You received that on April 23rd, 2021?
Miss Mitchell's cell phone?
Yes,
No, it came in April 3rd.
came in on April 3rd.
Yes.
Now, is that the only cell phone that your office received from Miss Micciolo's household?
I believe it was.
And when you did the extraction for that cell phone, Miss Micciolo's cell phone, did you check to see if any of the data was corrected?
First, I didn't do the extraction. Detective Nathan did the extraction. The extraction opened up fine without any issues. Did not appear to have any issues. When the extraction completes within the Celebrate software, it'll say file system extraction completed successfully.
Did you check to see if any of the information or data on the cell phone had been compromised, is what I'm asking?
In what capacity?
In the capacity of, is it not true that you can create fake text messages?
Certain applications, and third-party apps, you could make, I guess, send out a fake text if you want to, like a spoofing application.
Anything like that, yes.
Yeah, it's possible.
Now, you had mentioned you had come to the opinion that messages and search history had been deleted, correct?
That's correct.
Now, you're unable to say when those items were deleted.
An exact time, yeah. I'm unable to say an exact date and time when those were deleted.
And you're not able to say if it was done manually or automatically.
It depends on when it was deleted. So, again, if the system states messages are retained forever and they're missing, it would be indicative that it was deleted manually. If it goes back for 30 days and records in those 30 days are missing, again, it would be indicative that it was deleted manually.
But here you can't say when.
For this, I mean, I can give you an approximation, but the exact date and time, no.
Now, the prosecution had led you through a series of text messages marked as S-144, I believe, through S-159.
Sure,
And those series of text messages that you read out loud to the jury, correct?
I did.
When you read them out loud, is it fair to say that you were reading Mr. Gregor's text?
I believe so.
So I'm going to point you, for example, to one prosecution or state exhibit S10.
Sure.
Do you need a copy?
I do not have a copy up here.
Can I have permission to approach the witness?
Yes, sir.
Sorry, I'm showing you S10. You know when you're ready.
Thank you. Yes.
So S10, you actually read Mr. Gregor's response, correct?
Well,
Let
it's
me
not.
withdraw. On
Sure.
correct, you were asked what the text message was that Mr. Gregor sent, and you read it.
I did.
Prior to that text message, though, on that same page is a message from Brianna Micciolo.
That's after. It was sent after. You said prior.
But there's another message from Brianna, correct?
There's a second message on here from Brianna.
And it says,
Or sorry, I'm looking at this like it's Chris's phone. Yes, it's from Brianna's phone. Brianna is on the right side. So, I apologize.
No, it's fine. I appreciate the clarification.
Sure.
So there's a message that starts from Brianna first, correct?
There it is. That's correct.
And that message says, where are you?
It does.
So to put Chris's message in context, the response is, I'm home, send Corey inside.
No, let Corey walk inside the house, yeah.
Thank you. I appreciate the clarification. I'll just take that back. Judge, can I approach? Would you like me to approach, or did you want me to ask?
You don't have to ask, you can keep it approaching.
Thank you. Now, in terms of the messages, S44 through approximately S159, I'm going to correct myself, S144 through approximately 159, those are all coming from Mr. Gregor, correct?
I'd have to see it again, but I believe that was the ones that were all sent from his phone.
Yes.
Yes,
And each individual text message was marked as a separate exhibit.
that's correct.
But fair to say there's a conversation happening with the other side.
There is.
Now, depending on who the other side is, sometimes it was, what did you say it was Marcy? What's her name?
Marcy Brogna.
And sometimes it was Laura.
It was Laura.
Right? But there's conversations and text messages going back and forth, correct?
Yes, that's correct.
The state, for your testimony, highlighted Mr. Gregor's responses.
That's correct.
Now, you noted at some point that Mr. Gregor's cell phone went into airplane mode.
It did.
What was the date of that?
Sure, let me just pull up the chart.
Thank you.
So the date was April 2nd, 2021.
What time?
The first time we went to airplane mode was, sorry, I'm just trying to do the conversions from UTC to Eastern, 6:09:51 p.m.
And at 6:02 p.m. that same day, he received a message from Ms. Micciolo.
Yeah, he took the phone out of airplane mode at 6:09:54.
You took it out of airplane mode.
That's correct. And then it was put back in a little bit later.
And at 6:02, he received a message from Miss Micciolo.
That's correct.
Now, during your direct testimony, the state went through the hospital videos.
We did.
correct? And there was one video where you see Mr. Gregor walking down a hallway into a room,
That's correct.
and I believe that was marked at approximately 4:54 p.m.
Sure.
And I say approximately because I don't think there's a time set.
Yeah, just the exterior video.
And there was a second video where he's leaving that room with the male escort,
Yes.
and that was about 5:12 p.m.
Yes.
And the exterior entrance is marked at 8:23 p.m.,
Yes,
correct?
that's correct.
But that is again a 3-hour and 3-minute offset.
So it would have been about 5:20 p.m.
Thank you. You also mentioned that during your direct, there was an unanswered call at 8, withdrawn. There was an incoming call from Mark from DCP&P on April 1st, 2021,
Yes.
and that lasted 3 minutes and 44 seconds,
I'd have to look at the call log, but I believe that sounds right.
approximately.
Yes.
Can you hold a moment?
Sure.
Thank you. Now, when the cell phone extraction was performed, the way you view it, I'm going to describe it as a dialog box with different tabs.
It could be described that way.
And there's a section that says web history.
There is.
There's also a section that says applications usage log.
There is.
Now, is it fair to say, in your experience as an expert particularly, that I can access some applications through Safari?
You can.
So for
Or
example,
you mean like access the app through the web browser?
correct.
I mean, I would describe it like this. If I was to go on Facebook, just use Facebook for an example, for illustrative purposes. If I was to go on Facebook.com and access Facebook through my web browser on my phone, I could use Facebook with the web browser, or I could open up the Facebook application on the phone. For instance, if I wanted to chat with somebody and using Facebook on a Safari web browser on the iPhone, you'd probably have to go to like a desktop view in order to use the web browser. If you try to use the message, it'll probably ask you to open up the Facebook Messenger application. So in that sense, sometimes the website would trigger you to open up the application.
Well, when you receive the results, and I phrase it like that because sometimes you didn't always pull the extracting yourself, correct?
That's correct.
So when you receive the results and you look at it and you're asked to analyze it, did you do a side-by-side comparison of the different items?
In regards to...
So you received the results from Brianna Micciolo's phone.
Mm-hmm.
That would have been on one report.
That's correct.
And then you had the results from, say, Mr. Gregor's iPhone 11 on a different report.
That's correct.
Did you do a side-by-side comparison of those two?
Only for text messages.
And at one point, the state actually asked you to focus, I believe, on 7 different items they call tasks.
Sure.
And that became your focus.
It was.
And you made sure to answer comprehensively those specific 7 questions.
That's correct.
Now, when you did the favicons that you talked about, am I saying it right?
That's it.
That was for Pizza Hut.
That's correct.
Do you see any other favicons for other searches that you couldn't quite find?
I did.
You didn't look at those.
I saw what they were. I can tell you where he came from before he went to Pizza Hut.
Were you asked to dig into that? By the state?
They were curious of what deleted history was.
Now, I'm going to ask that you take a look at what I've marked as Defense Exhibit 14 and 15 for identification.
Can I
see those? I've never seen them before.
I'm
pressing
your
the button.
Let me just take a look.
screenshots essentially of part of the result from the application's usage log in the web history.
That's correct.
Now, looking at the web history first, April
Sure.
2nd, 2021. Very top line, 3:49:50 a.m.
Sure.
Looks like someone accessed Gmail.
No. So inside the Sidebar Physical Analyzer software, right here, you have a little drop-down arrow. The emails are also in there as well. So these would be emails on his phone, not associated with the Safari web browser.
Now, looking then at the next exhibit that you're holding for application usage log. Top line, April 2nd, 2021, 3:49:54 a.m. That's about a 4-second difference, correct?
Where are you at? The top line, 34954?
Yes.
Yeah.
Going back to the last exhibit.
The web history one?
Yes. Thank you for bearing with me as we shuffle.
That's all right.
April 2nd, second line down from the top, 2021, 12:36:20.
Yes,
It's again marked as Gmail as the title.
that's correct.
Going back to that second exhibit you're holding, 15. April 2nd, 2021, second line down, 12:36:14 p.m., correct?
Yep.
And again, we're comparing the Gmail or the application's history log with the web history log, correct?
That's correct.
I'll take those unless you do.
Yeah, you can take them.
Now, in terms of the gym videos,
Yes,
and again, that's at the Atlantic Apartments, correct?
Atlantic Heights.
Atlantic Heights. You focus your time period for the gym videos from March 2021 to April 2nd, 2021.
The initial pull request was that time frame.
What was the focus after the initial pull request?
Everything from the gym, as far back as the DVR went.
And which videos were viewed?
I couldn't tell you which ones the case officer reviewed. I assume they went through most of them.
In terms of as far back,
Sure.
right, that statement you made, how much gym video did you get?
So the video went back to January 30th. It's approximately, if you add both together, it's like 90,000 individual clips.
And did you personally watch all 90,000?
I don't know.
Is it fair to say that there might have been some case officers that watched pieces of those 90,000?
There were.
And I presume, correct me if I'm wrong, they would come back to you and again highlight certain videos for your interest?
Yeah, if there's anything there.
Now, you saw a gym video, was it March 20th, 2021?
I did.
Did you happen to notice a gym video from March 29th, 2021?
I believe they might have mentioned it. I don't recall watching it.
In the videos that you did watch of the gym, again focusing on March 20th, 2021 through April 2nd, 2021, did you see other videos of Mr. Gregor and his son just working out in the gym?
There were.
Judge, can I have one moment?
Sure.
Last question. How many videos did you see of Mr. Gregor and son just working out in the gym without issue?
Without the issue? And I didn't see them, I spoke.
Objection, what's the issue?
I'm not sure what the objection is, to be honest.
The issue being an allegation of some wrongdoing on March 20th and not on other occasions? Is that what you mean by that?
Yes.
It's permissible. Overruled. Good answer.
Sure.
Did you need to repeat the question, or
You said how many instances did I view personally of them working out without issue?
in that time period? Yes.
In the time frame from like January 30th up until April 2nd?
Yes.
I think there might have been somewhere between 8 to 10 instances of them, at least.
Thank you.
And can I just elaborate on one other thing, too, with your web history, just to make sure it's clear for everybody else
I
involved?
would ask to leave that for redirect. I presume
Sure.
ask you questions.
Very good.
What do you want to elaborate on?
Can I just see the web history, or the quote web history in the Safari browser?
I'm not sure if this is what you're referring to, but
It was the defense
S122?
exhibits.
The defense
two defense
exhibits. Can I use your exhibits?
D14 and 15.
D14 and D15, you didn't create these, right?
I did not. I just
Did you
saw
ever
them.
see these before sitting on the stand today?
Just today, just now.
Okay, I'm approaching with D14 and D15. Could you take a look at them?
Sure.
And explain what you wanted to explain?
Sure. So before we're comparing our usage to the Gmail history, web history, these listed date and times on here are the dates and times emails were received, not indicative of him utilizing the Safari web browser. That's pretty much it.
With regard to the deleted text messages in the defendant's phone with Ms. Micciolo, were you able to eliminate the idea of spoofing because the entries were actually missing from the defendant's phone when the text appeared in hers?
So,
It's appropriate to redirect him back to a topic that was a forward directed for us, so it's permissible.
Were entries actually missing from the defendant's cell phone?
yeah, so to elaborate on both points, right? The text messages in this case were from the MMS SMS.db. This is the native messaging application for an Android device. It was not from a third-party application. Her phone was not rooted. She did not have master access to really go back and modify that database in any way to spoof messages. In regards to the messages on Mr. Gregor's phone, they were just completely missing. And again, sequence gaps within the SMS database were consistent with messages that were sent from Ms. Micciolo's phone.
Okay, and on cross, you had been asked a question about whether you could tell when a text message is deleted, and I think you said you could approximate it?
Again, depending on when the search was conducted or the type of search or type of deletion was done, obviously the deletion has to happen after the last message was received, or else, it wouldn't be there. Can I say when a text was deleted, or, hey, maybe text came in from Brandon and got deleted today, and then more text came, let me phrase that again. Say Brandon sent Mr. Gregor 10 text messages on May 1st. Mr. Gregor could have deleted them on May 1st. Then Ms. Micciolo sent Mr. Gregor 10 more text messages on May 2nd. He could have deleted them on May 2nd. All I can tell you is that deletions happened after the device occurred. In regards to deleting stuff within Safari browser, Mr. Gregor's phone was missing. I could tell you the exact date and times of when searches were missing. So if we look at the sequence gap on Mr. Gregor's phone, in this case, it goes from 44134, then it goes to 44359, 44360, 361, 362, obviously with the 4 4s in front of it. So we can see there's a sequence gap of approximately 225 missing text messages. 225 missing entries in his web history. In the Safari browser, you have 5 different ways you can delete text messages. 5 different ways you can delete your search history. You can either A, individually delete entries piece by piece. B, you can delete your history by the last hour. C, you can delete history by today. D, you can delete history by today and yesterday. And E, you can delete everything. In this case, I would approximate, since the first entry on here at 44134 is on April 1st, 2021 at 2:58:16 a.m. Again, we need to realize that time is in UTC, not Eastern Daylight Time, so that entry would actually refer to a time on March 31st, 2021. The first entry, that 44359, the date and time of that is April 2nd at 9:14:44 p.m. I know the last Conscious and Sleepy was one of the last searches that was conducted. Again, I can't give you an exact time when it's conducted, but at some point after 3:08 p.m. Eastern Daylight Time, but before 5:14:44 p.m. Eastern Daylight Time, it more than likely occurred that Mr. Gregor hit the delete today and yesterday search, as there's no message on April 2nd prior to that, and then there would be obviously no recent saved searches from April 1st.
I have nothing else. Thank you.
Any reproach?
Just briefly, Judge. Referring to D14 and 16 for identification on
Sure.
pages that showed this.
Yes.
You didn't see those pages before today as they're prepared, correct?
No, I mean, indirectly, like looking at the physical analysis software we took the screenshots from, like I've seen the screen of where these would have been pulled from before. I can see that came from these phone extractions. These two actual printouts, I have not seen before today.
But you've seen that information in the extractions that you have, correct?
I have.
And in terms of deleting text messages,
Yes.
you mentioned briefly that redirect.
Mm-hmm.
I could also just swipe left and delete the entire conversation in one motion, correct?
You could.
No further question.
All right, Detective, thank you for coming in.
Thank you very much, sir.
I see counsel somewhere. Members of the jury, thank you so much for your attention today. We're going to recess till tomorrow. I discussed with the attorneys the schedule. I think you can arrive about 9:45. So a little bit later, take your time getting here, and then we'll get the jury assembly 9:45 or so. Hopefully we'll have you over here by 10. We'll start at 10 with our next state's witness. Again, don't discuss the case with anyone. Don't do any research. Don't look anything up. And then when it does come up to you and tries to discuss with you, don't tell your fellow jurors. Report it to me immediately. Continue to tell your immediate family and your employer that you're just on jury duty and don't have any further discussions about it. Anything from counsel before we have the jury retire for the day?
No, Judge, thank you.
Thanks so much, ladies and gentlemen. We'll see you tomorrow.
It is.
never slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast, I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all